Well, good afternoon. This is House Judiciary Committee. It's March the 5th, 2025. Delegate Williams is not in the room. She just stepped out. Yeah, is Miss Braveboy here or is she virtual? Kara, do you know, is Miss? Well, yeah, actually, she doesn't have an excuse anymore. The election's over. She can be here. She has a representative here. Well, we don't have anywhere else we can go just yet, so we need her. Here she comes. Let's get her to the table. Delegate Williams, the representative for the county executive, soon to be county executive, Braveboy.
Is from her office, yes.
All right. Greg Lickenbrock, Mary Kina.
Mary's right here.
Matthias Cacciero. Come up to the table. Delegate, when you're ready, that'll be 3 minutes.
We're getting it together. Okay, good afternoon, Chair Clippinger, Vice Chair Bartlett, somewhere, oh, there she is, and the best committee in the Maryland House of Delegates, the Judiciary Committee. I am Delegate Nicole Williams of District 22 in Prince George's County, testifying in favor of House Bill 1287. This bill would prohibit a person from manufacturing, selling, offering for sale, purchasing, receiving, or transferring in Maryland a certain convertible pistol, which is a semi-automatic pistol that has been converted into a machine gun solely by attaching a switch. That is a type of auto sear. Glock and other manufacturers uniquely design their pistols in a way that make them easy for users to convert them into illegal machine guns by simply just using a screwdriver and a small piece of plastic known as a Glock switch. While unlawful both under federal and state law, the switch can easily be purchased illegally for $25 or made with a 3D printer at home. This creates an extremely accessible weapon of mass destruction when placed in the wrong hands. In fact, shootings involving automatic weapons are becoming more and more prevalent across the state of Maryland. Most notably, the tragic mass shooting at Morgan State's campus anecdotally involved a gun with a Glock switch. In addition, shootings have occurred in other parts throughout the state using these types of guns with these switches, such as in Clarksburg, Frederick, Townsend, Pikesville, and Baltimore. Each of these stories is a result of the inaction of Glock in addressing this issue, which the company has been aware of since 1987. Passing this bill is one way to hold them accountable, limit the spread of machine guns in Maryland, and keep our streets safe. This bill does not require current Glock owners to change or turn over their guns, nor does it impact their ability to use, carry them, provided that the owner is properly licensed. This bill does not prohibit any future sales of guns to law enforcement, correctional officers, active military members, agencies, and there's some amendments that will be addressing these, just kind of fleshing out more of these exceptions. But you know, law enforcement will still be able to purchase Glocks that they currently have contracts with. Glocks and other companies that manufacture these convertible machine weapons have been aware, like I said, of this issue since about 1987, and they've chosen to put profits over people, over actual human lives. And so we need to do our part here in Maryland to keep our community safe. And for these reasons, I'm urging a favorable report on House Bill 1287.
Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and distinguished members of the House Judiciary Committee. For the record, I am Perry Paylor, Deputy State's Attorney for Prince George's County. I appear before you today on behalf of the State's Attorney for Prince George's County, Aisha Braveboy, to express our office's strong support for House Bill 1287. The recent proliferation of these conversion devices in Prince George's County and throughout Maryland represents a dangerous evolution in firearm-related crimes. These small, easily concealed devices can transform a standard handgun into a machine gun capable of firing multiple rounds with a single trigger pull, dramatically increasing the potential for both lethality and mass casualty. In Prince George's County, we have observed a disturbing trend where these devices are becoming more accessible through various channels, including online marketplaces and 3D printing technology. In 2023, Ms. Braveboy established our Firearms Enforcement Unit. This unit that I lead regularly investigates and prosecutes cases involving possession of illegal firearms and their modifications, including the increasingly prevalent Glock switches, devices designed to convert semi-automatic firearms into fully automatic weapons. These devices pose an unprecedented threat to public safety and law enforcement officers in our communities. Recent data reported by Prince George's County Police indicates that we have recovered 47 Glock switches last year in 2024. This year to date, we've recovered 9 Glock switches already. Just recently, in a particularly concerning incident, an individual was arrested in Laurel and charged with multiple federal offenses related to firearms, including the possession of these illegal conversion devices. This case exemplifies how these dangerous modifications are increasingly being recovered alongside other serious criminal activities in our communities, demonstrating the urgent need for passage of House Bill 1287. The provisions proposed under House Bill 1287 would provide crucial tools for prosecutors to combat this emerging threat. For that, we will request a favorable report for House Bill 1287. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and committee members. My name is Mary Kana, and I am Policy Counsel for Everytown for Gun Safety. On behalf of Everytown and our Moms Demand Action and Students Demand Action volunteers across Maryland, I urge a favorable report on House Bill 1287. This bill would ban the future sale of semi-automatic pistols that are easily convertible into fully automatic machine guns, specifically Glock pistols and their copycats. It goes without saying that machine guns are exceptionally lethal weapons designed for use on the battlefield, meant to inflict maximum damage in minimum time. But Glock and other gun makers who have copied their designs enable anyone to make a do-it-yourself machine gun at home. They know their design enables the conversion of their firearms into rapidly firing handheld machine guns. Glock has known for decades that its products, the most popular semi-automatic handguns in America, can easily be turned into illegal machine guns in minutes by anyone with a small $25 device and a screwdriver. No technical expertise or special tools needed. This device is a type of auto sear, popularly known as a Glock switch, because it was created and popularized by people who recognized that Glock-style pistols are uniquely easy to convert into automatic weapons. Glock has refused to fix this problem by updating its pistol design for nearly 40 years. Glock can change this problem tomorrow. They could have changed this problem at any time since 1987. They have chosen not to, putting profits over people, innovating toward lethality and disregarding safety. We need to address gun violence from every angle, including by removing these dangerous weapons from the marketplace until Glock changes its dangerous design. Maryland must continue to lead the fight to hold bad actors in the gun industry responsible for their role in worsening our gun violence crisis. Thank you.
Dear Chair Clippinger, Vice Chair Bartlett, and honorable members of the committee, my name is Matias Cachero, and I'm the Deputy Director of Government Affairs for the Office of the State Attorney for Baltimore City. I'm here to express strong support on behalf of the Office of the State's Attorney for Baltimore City for House Bill 1287. This is a straightforward but essential bill that would directly enhance public safety. This bill would address a gap in existing legislation by prohibiting the manufacture, sale, purchase, receiving, or transfer of a convertible pistol, and like the delegate mentioned, would not prohibit owners who already have the weapon from having it. And this kind of pistol can be converted into a machine gun, which is incredibly dangerous to the public. I would like to also note that when someone commits a crime and with a firearm, there is already a 5-year minimum penalty, but when they commit that crime with a machine gun, the penalty doubles to 10 years. This is a misdemeanor charge of 3 years, which is already less than that. Just for Baltimore City, I think a lot of the important points have been mentioned, but in the last 2 years, over 100 convertible pistols with the switches have been found by Baltimore City Police Department. In Patterson Park in Baltimore City, a convertible pistol with a switch was used to fire at police officers. This can turn a single homicide into a massacre, and these guns need to get off our streets, and this legislation is an important tool for prosecutors to have in their toolbox to ensure that happens and increase public safety. I urge you to give a favorable report on House Bill 1287. Thank you for your time.
Starting with Delegate Taylor.
Thank you, Mr. Chair. And I think this question would be best for Ms. Kenna. In the bill, it refers to convertible pistols, so you don't specifically say Glock, right? So are there other manufacturers or other categories of pistols or firearms that can be converted in the same way that a Glock can be converted?
There are a couple of other kind of what we call Glock copycats, folks who have the exact same design as Glock. But there's lots of other guns that people can purchase that do not have this design. And so, so overall, there will be lots of other options if people wanted to purchase a semi-automatic pistol.
Yeah, I'll just add, another company that has a similar design to Glock is Polymer 80. That's like a popular ghost guns company. They've copied Glock's design. Delegate, do you have anything else?
Oh, no, I just was receiving a note. I have someone virtual,
We
but that's okay.
We do have our virtual firearms expert who's going to testify, I believe, on the next panel, and he can really break down exactly what it is about Glock-style pistols that make them so dangerous.
Okay, then you've answered the question. Thank you.
Okay, thank you.
Delegate Cotton.
Yes, thank you, Mr. Chair. I gotta wait for my mic. Okay. Thank you, Mr. Chair. I appreciate it. This question is for Ms. Kenna. A lot of people already have Glocks. So my question is, how does this bill impact Glock owners? Because we hear a lot of talk from people who oppose gun safety measures about how it negatively impacts owners. So my question is, does it limit their ability to buy replacement parts, have their guns serviced by dealers, or carry them anywhere they are legally allowed to?
No. If you already possess a Glock, this law will not touch that. You will be able to service your weapon, buy new parts for it, get it repaired at your local gunsmith without any issue. This is a sale ban for future sales and does not impact possession.
Can I have one more, Mr. Chair?
One more.
Yes. My other question is, are Glock switches a growing problem in this state, given your expertise?
Yes, based on data from the state, from specific cities in Maryland, and from ATF nationally, Glock switches are on the rise exponentially. ATF between 2019 and 2021, I believe, recovered more than 5,000 Glock switches. In the following few years, they recovered 30,000.
Wow, thank you very much. Thank you, Mr. Chair.
One more thing, in Baltimore City from 2023 to 2024, they almost doubled from 34 to 64 recovered convertible switches.
And Delegate, I would say one thing. We still believe there's underreporting because a lot of officers who actually retain the weapons are not recognizing the switches. So sometimes when we have people go back in inventory, they can say, here, oh, these are a few guns that actually have the switches attached, but they honestly just didn't know what they were looking for. So we still believe there's an issue of underreporting.
Thank you all. Delegate Valentine.
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill, and thank you for the panel for being here today. The secondary gun sale, I kind of looked at this component of it. I'm looking at it as a retired officer's standpoint. So I'm sure the panel's aware that many agencies in this state allow officers the opportunity to buy a firearm upon their retirement.
Right.
And a lot of these agencies, myself included at one point, worked for an agency that had Glock pistols. So my question is, would this bill, from what I'm reading, prohibit that secondary sale from an agency to allow me to purchase a firearm, for example, that I carried every day for 15 years. Now I'm retiring and now I cannot buy that firearm. Would this bill prohibit that?
Yeah, so we're working on a couple of amendments, which I found out 30 minutes ago, I think already, which is why you don't quite have them quite yet, but you will have them hopefully soon. And that is one of the amendments that we had discussed doing. We had that conversation with FOP about the retired law enforcement officers, just like you said, their ability to purchase their service weapon upon retirement. And so that is one of the amendments that we're working on.
Thank you. Thank you, Mr. Chair.
Delegate Tomlinson?
Thank you, Mr. Chair. So obviously, it's been brought up, Glocks, there's plenty of people that already have them. You said it's not going to affect folks that already own them. How do you envision this, if this bill passes, what do you think will happen? What's going to be the next step? Is Glock or any similar manufacturers, are they going to, is the hope that they would change the design or just stop selling them in Maryland, or are they going to, file a lawsuit? I know you can't predict whether they're going to file a lawsuit.
Yeah, I can't predict what they would do. Ideally, we would like to think that they would change their design. As I mentioned, there's lots of other gun manufacturers whose design does not allow for these types of switches to be added to their guns. And so hopefully Glock will follow suit and modify the way that their guns are designed in order to prevent this from happening. They've known about this for over 30 years, and they've chosen not to modify the design. Not really certain why. It seems like they're more worried about their costs than they are, focusing on not making sure their guns don't turn into automatic weapons. But that is the hope, that they would just simply modify their design.
And if they did modify their design, this wouldn't be an outright Glock ban?
It wouldn't apply to them.
Okay. All right, thank you.
Thank you, Mr. Chair. So you have answered that there are other guns to which the switch can be added. Is that correct?
Yeah, so the Glock style of firearm has been copied by other companies. One of the companies I can name is Polymer 80. And our firearms expert can give you a really good description of all of that.
Okay, well, where I'm really trying to go is you've talked about or spoken about what it can do, how it performs when it's added to a gun. So let's take, it goes into like machine gun category. So what happens, or can you put one on a gun that's already automatic, a machine gun? And what does that look like if that happens?
I don't know that a Glock switch would impact an already fully automatic weapon. But installing one into a Glock gives you essentially a handheld machine gun that is difficult to control. The recoil is really hard, and
That's on a regular.
On a regular Glock, you can add it's about the size of a Lego. You can add it to the back and shoot as many bullets as you have in your magazine and as fast as you can.
Yeah, it'll shoot about 1,200 rounds per minute, is what the studies have shown.
Okay.
Once that switch is added.
Okay. Thank you. Thank you, Mr. Chair.
To the Deputy State's Attorney. So this would carry a 3-year penalty as opposed to a handgun on person, which carries a 5-year penalty. Why? I guess it's just being inserted in that same general area of the law, so I get it if that's why, but I guess I'm kind of wondering why? Why 3 years?
It would be the same penalty that currently exists for other auto sears.
Okay. Delegate Grammer.
Thank you, Mr. Chair. Are you familiar with the Maryland Handgun Roster Board?
Yes.
Are you aware that Glock pistols have been approved by the roster board as suitable for law enforcement and self-defense?
Yes, we are aware that it's listed on there.
Have you reviewed the handgun roster to determine which pistols could be impacted by this bill?
We have not, but we are aware that Glock is one of the pistols that's listed on there.
Could you tell me, like, have you maybe looked physically at other pistols to see which pistols might be banned should we pass this bill and someone decide to use one of these switches?
There would probably be a couple other ones that are on that list that would probably also be banned, as I mentioned, the Glock copycats.
Okay, are Glock switches legal to purchase or possess under federal or state law?
They're illegal,
They're currently.
as I stated in my testimony.
Okay, not legal. Okay. And are you aware that the Attorney General's press release states that Glock switches are legal?
I hadn't read through the Attorney General's press release,
Okay, all right, thank you.
but they're illegal under federal and state law.
Further questions for the panel? Seeing none, we thank you all very much. That concludes the first panel. I'm going to go through, I'll ask Yasmin Bryant, who I believe is, I'm reading this correctly, Miss Morgan State? All right. And then Margaret Hilton, Aaron Earp, Jennifer Yacovici, I'm just seeing who's here. Layla Gretton, Joyce Banjo. All right, and whoever would like to go first, please go right ahead.
Greetings, everyone. My name is Yasmin Bryant. I'm a senior studying sociology and political science at Morgan State University, where I also serve as Miss Morgan State University. I'm here today not only as a representative of my institution, but on behalf of all Maryland historically Black institutions from Eastern Shore to the west side of Baltimore, because we indeed, have a serious gun violence problem. My story with gun violence began on October 3rd of 2023 on the campus of Morgan State University, where on a night of celebration, we students were met with the sound of 5 shots that sent our world into a standstill. And while many of us in Baltimore have heard the sound of gunshots, it was nothing like this. This was rapid fire, it was very quick, and it was something that sent us all in a state of confusion that made us standing targets for the shooter. And as the next round of shots came, we ran desperately to avoid being shot. And I'm sure, as you all may know, or even if you don't know, it is very hard to run from bullets in a formal gown and heels and suits. The media later reported that one of the guns involved in the shooting was equipped with a Glock switch, a small piece that can be made with a 3D printer and converted into a handgun into a fully automatic weapon. This is a growing problem across the nation, where Glock handguns are easily turned into a machine gun in a matter of minutes with the addition of the Glock switch that can be made at home. This piece is gaining nationwide attention in the younger generation, Generation Z and Generation A, with TikToks, Instagram Reels, and also on YouTube. The jokes and the songs being made with the handgun and the switch itself. If you ever hear kids singing on TikTok or Instagram, "He's scared of the switch," that's what they're talking about, this Glock switch that we're discussing today. Now, I'm not an expert on guns, and I will not pretend to be, nor am I an opponent of the Second Amendment, but I am an opponent of attacks on innocent blood, which I believe that we are all as well. I think we can all agree that machine guns should not be accessible to children and to teenagers who at a moment's notice can turn their classmates into the victims of a mass shooting. Glock has known about this problem for decades and has allowed it to grow. So, when a dollar bill holds more value than human life, we face a tremendous problem. Therefore, we urge you all to favor our lives more than a dollar bill and decide favorably on this bill. Thank you.
Is Lance Hatcher here? Lance Hatcher from Morgan State? Okay, I was just checking because you're from Morgan State, wanted to do that. Whoever would like to go next.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Margaret Hilton, and I lead the Gun Violence Prevention Ministry at St. John's Episcopal Church in Chevy Chase. Most of our church members live in Delegate Kaufman's district, District 18, or like me in District 16. I'm here to ask for a favorable report on HB 1287. St. John's has been impacted by gun violence. Our teens at Bethesda Chevy Chase High School and their families are fearful after 2 recent lockdowns. In the first incident, gunfire broke out at a nearby park, and 2 students were later arrested on gun charges. Just a week later, the high school went into lockdown again, and a student was later charged with having a concealed weapon on school grounds. Last October, an armed carjacking on Bethesda Avenue took place just a half mile from our church. As leader of the Gun Violence Prevention Ministry, I hear stories, and each one is painful. Whether it's about missing a beloved relative during the holidays, encountering an armed mugger on the street, or receiving an "I love you" text from a child during a school lockdown. My community has experienced the trauma of gun violence, and we fear the even greater threat posed by fully automatic machine guns. HB 1287 will protect us by prohibiting the future sales to civilians in Maryland of handguns that can be easily converted into machine guns with a Glock switch. Thank you for listening to me, and I ask for a favorable report.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Layla Greeton. I'm a high school student and the founder of Team Enough Baltimore, a youth-led initiative for gun violence prevention under the Brady campaign. I'm here today to voice my support for House Bill 1287. House Bill 1287 bans the sale and distribution of firearms that can be easily converted into automatic weapons by the use of auto sears, also known as Glock switches. These converted pistols can shoot up to 1,200 rounds a minute and have a devastating impact on our communities. Furthermore, guns with these switches installed are the rising weapon of choice in Maryland. Between 2023 and 2024, at least 100 of these illegally modified pistols were recovered. What is even more alarming is that a majority of the individuals thought to be connected to these incidents are under the age of 21. My generation is impacted the most by this crisis. Young people are both the primary victims and perpetrators. The accessibility of these deadly weapons, combined with inadequate education and intervention, has created a dangerous cycle. I have the privilege of focusing on my future instead of living in fear of being drawn into gun violence. So many of my peers do not have this privilege. Without urgent action, more of these convertible pistols will be able to fall into the hands of Maryland's youth, exacting even more of a toll on our society. Thankfully, there's a solution: easy design changes, and it is the responsibility of the firearms manufacturers to take this action. The companies are aware of the convertible nature of their firearms and have chosen not to make design changes. This industry racks in billions in profit every year, while our communities are the ones reaping the consequences. By allowing for the installation of illegal modifications, it is evident that these industries are more focused on prioritizing profits than public safety. This bill simply mandates that manufacturers take responsibility and make reasonable changes to their design. We are at a crossroads. We can either allow these companies to continue their production of these weapons, or we can take a stand to protect our communities and save countless lives. Therefore, I strongly urge a favorable report for HB 1287. Thank you.
Whoever would like to go next.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and the members of the House Judiciary Committee. My name is Joyce Banjo, and this session I serve as the legislative intern for the wonderful Delegate Nicole Williams. I'm here today to offer a favorable testimony for House Bill 1287, Criminal Law Firearms Crimes Convertible Pistols. As a current college student who has attended Maryland public schools for my entire life, I regularly have to face the harsh reality of the likelihood of a mass shooting, as the frequency and deadliness of school shootings have increased. It is my firm belief as a student advocate that our communities, including our education campuses, should be safe places for learning. Students deserve the opportunity to have a safe education and be free from fear of harm. Unfortunately, this is a luxury that too few students of my generation are afforded. Weapons of mass destruction, including these very same convertible pistols, have been used to end too many lives across the nation, and particularly in Maryland. Passing House Bill 1287 is an effort to curb such deadly shootings. Moreover, in the last session, the Maryland General Assembly successfully passed legislation that prohibited the manufacturing, sale, and transportation of rapid-fire activators in House Bill 810. And the bill before us today furthers these very same efforts and demonstrates a commitment to public safety. I wholeheartedly believe that this bill takes us one step closer to making all of Maryland safer. Thank you for your time, and I urge you to vote in favor of House Bill 1287 today. Thank you.
My name is Jennifer Iacovisi, and I'm here to read the testimony of my friend Denise Reed, who wasn't able to be with us today in support of HB 1287. The Maryland chapter of Moms Demand Action urges you to protect all Marylanders and prevent continued senseless gun violence by requiring Glock and other companies that copy them to change their uniquely convertible designs. The following are Denise's words. Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and esteemed members of the committee. My name is Chaplain Denise Reed with the Baltimore City Police Department since 2016. I reside in beautiful Baltimore, Maryland, District 40, and I'm a constituent of Delegate Conway. I am a proud volunteer with Maryland Moms Demand Action, and it's been a privilege to serve as a survivor membership co-lead for our chapter since 2018. Sadly, I am a valiant survivor of heinous and senseless gun atrocities that have traumatized my family for over 80 years. My uncle was killed before I was born in 1964. My mother's brother Sheldon, my cousin Derek, age 16, and my two cousins' mother Angela were all killed in the 1980s. With a broken heart, I share that my only precious son, Tavon Terrell Waters Sr., was shot in the neck and gravely wounded on October 18th, 2006, and passed away on April 1st, 2009, at age 25. My daughter was only 6 months old when my son Tavon was shot. She will turn 19 in April. Jazaniah's heart still aches from losing her big brother 16 years ago. I never want another family in Maryland to feel the pain that I feel. These Glock switches are making our communities more dangerous by the day. We need to hold gun companies accountable for turning a blind eye to our pain and suffering while they make record profits. I ask for a favorable report on HB 1287. Thank you for your time.
Greg Lickenbrock is virtual, or well, I'm sure he's a real person, but is here virtually. And we'll see if there we go. So Mr. Lickenbrock, please, if you'd like to testify for 2 minutes.
Thank you, Mr. Chairman, and thank you for members of the committee for the opportunity to testify today in support of House Bill 1287. My name is Greg Lickenbrock, and I'm the Senior Firearms Analyst for Everytown for Gun Safety. Before joining Everytown, I spent a decade working in the gun industry as a magazine editor, which gave me the opportunity to test hundreds of firearms, attend media events and training courses, and meet people working at every level of the industry. I've worked extensively with Glock and its products. Glock switches, as you've heard, are tiny third-party devices that cost as little as $20, are easily 3D printed, and can be installed on the back of a Glock slide in seconds. Once in place, the switch allows the shooter to hold down the trigger and fire dozens of shots in the blink of an eye. Glock's pistol design is uniquely easy to convert into a machine gun because of the trigger bar, which provides surface area for the Glock switch to contact, as shown in my written testimony. Each time the gun returns forward, the Glock switch's leg impacts this trigger bar and pushes it downward, causing the gun to fire. As long as the shooter holds down the trigger and the gun has ammunition, the gun will continue firing. The only handguns that have this problem are those that use Glock-style trigger bars, including Polymer 80 Ghost guns, as my colleague Mary mentioned earlier. Other pistols made by the largest manufacturers would require extensive engineering to convert into machine guns because their trigger bars are broken into smaller, disparate components that are shielded from interference. Glock has reportedly known about this problem since around 1987, when the man who invented the first switch met with the company's founder to show him his design, but Glock has publicly insisted that it cannot fix the problem, despite Glock switches having been used in at least a dozen mass shootings nationwide. And between 2019 and 2023, police across the US recovered over 11,000 autosears, including Glock switches. While those devices are already prohibited on the state and federal levels, they're still easy to obtain. By prohibiting the sale of such easily convertible pistols, this bill would make it harder for criminals and others intent on harm to fully obtain fully automatic weapons. Thank you.
Questions, Delegate Phillips.
So this question is going to be for Mr. Lickenbrock, and you may have already answered it, sufficient for me, but I just want to be clear. Often in terms of guns rights, we want to make sure that people have options. In Maryland currently, do you know where Glock rates in terms of the number of guns sold versus their competitors? And what other options would a person who wanted to purchase guns have? And you can name some names, manufacturer names.
Sure. So I'll say that I don't know how many Glocks specifically are sold into Maryland. But I can say that Maryland, since 2020, has purchased well over 8,000 pistols a month. So that's quite a market. And Glocks are very popular, but every company produces pistols that compete with Glock, such as Smith & Wesson, Sig Sauer, Taurus. And those companies do not produce pistols that are easy to convert into machine guns in this way.
So this would not take access to the ability to purchase a gun away from anyone in Maryland?
Absolutely not.
Thank you.
Delegate Embry.
Thank you, Chair. Can you talk about other states, what they've done in terms of legislating design features and how Glock and other gun manufacturers have responded to that?
Sure. So one example that might be helpful is California. In 2007, they required some additional safety features in their pistols. One of those is a feature called a magazine disconnect that prevents a gun from firing if the magazine is removed. It's a smart safety device because a lot of people assume that a gun is unloaded if the magazine's been removed. However, in Glocks, particularly, and other handguns, if there is still a round in the chamber, the gun can fire. A recent study even showed that almost 300 people have died because gun makers do not include those features in their guns. However, the way that the California law was written, they required that those features on new models, and companies like Glock were allowed to continue selling older models into the state that don't have that feature. So Glock, for example, instead of adding that to their guns and continuing selling them into California, they just continued selling the old models that don't have those features that could have saved lives.
Delegate Hamilton.
Thank you, Mr. Chair. Also a question for you, sorry. Mr. Lickenbrock. So you kind of said this at the end of your testimony that you were talking about how the auto series have been banned by the federal government and how in the state of Maryland we've obviously banned the switches. So I'm just trying to understand your logic on if we essentially say you can't get the gun anymore. I guess how is that going to bring down, if you can't get it's already a crime, it's already legal to possess the switches, but now we're going to say you can't have the gun that goes with the switches. My fear is that this is just going to turn people more towards the black market or 3D printers to create ghost guns. So I'm just trying to understand your logic there.
So I mentioned in my testimony that polymer 80 ghost guns also use these Glock-style trigger components. So by incorporating this law here, you would actually cut down, at least make it harder for people to even, as soon as you made a gun like that, it would be considered a convertible pistol, and it would also be a problem according to this bill. But honestly, this is mostly a manufacturing problem that Glock has known about and should fix. You can't stop 3D printing with current technology, with the current state of the market, but you can make it a lot harder to modify widely available pistols by simply preventing that in the future with this bill.
Okay, thanks.
Delegate Boucher.
Thank you, Chair. Thank you, Mr. Lickenbach, for bringing your information to this committee. How many individuals were murdered last year in the state of Maryland by pistols, handguns, and how many of that amount are Glock with this auto shear on it?
So I don't have that the number of people murdered with pistols in front of me at the moment. I'm just a firearms expert, sir. But I do know that there have been several incidents in the state involving these, and even one, in my eyes, is worth looking at and stopping.
So you don't think this would have a sizable impact upon the handgun murder rate in the state of Maryland?
That is not what I said, sir. I believe that preventing future deaths with these devices would have a significant impact on public safety in Maryland.
But you don't know the amount?
I can tell you how many were recovered nationwide. I can tell you that they were used in the Morgan State University shooting from reporting. I don't have that stat directly in front of me, sir.
Thank you very much.
Don't see any more questions for this panel. Thank you very much. We will have one last panel, one last time for Lance Hatcher from Morgan State. All right. Stephanie Mavronis, Anthony Barksdale, John Herzog. They're going to get to representatives of Baltimore City Police. And while she's doing that, Ms. Mavronis, if you'd like to pull a microphone in front of you and speak, we'll let Mr. Herzog sit down. I think she's trying to find Mr. Barksdale.
All right.
Please go ahead.
Okay. Good afternoon, Chair Clippinger, Vice Chair Bartlett, Delegate Williams, and members of the committee. Thank you for the opportunity to testify. I'm Stephanie Mavronis, Director of the Mayor's Office of Neighborhood Safety and Engagement in Baltimore City, here to support HB 1287. While Baltimore has made substantial progress reducing homicides and non-fatal shootings in partnership with law enforcement, community-based organizations working to build safer communities, and residents across the city, we understand that any one life lost to violence is one too many. And in order to maintain progress, we must respond to rising trends that threaten to undo the gains we've worked so hard to achieve. Over the past few years, we've seen an alarming increase in the number of modified Glock handguns that we're seeing in our communities. Those seeking to do harm and carry out violence are exploiting Glock's design to attach switches that turn these handguns into illegal automatic machine pistols that can fire as fast or faster than military-issue weapons. You've heard already that a modified Glock handgun was utilized in a mass shooting at Morgan State University in 2023 that injured 4 young women and a young man, where my team saw firsthand the widespread destruction and trauma made possible by these modified weapons. They threaten our communities, and by sacrificing accuracy for lethality, there is substantially increased risk of mass shooting incidents where additional victims are injured or killed beyond the perpetrator's intended target. While the switches themselves are prohibited under Maryland and federal law, they're still being purchased illegally. They're still being 3D printed. And we believe that until Glock changes its design to prevent easy modification, these consequences will continue to be devastating. We need sensible gun legislation like this to protect Baltimoreans and Marylanders from the growing safety threat posed by convertible pistols. While the city, in partnership with Everytown and the Attorney General's office, is pursuing legal action to halt the spread of easily modifiable handguns until Glock alters their design, HB 1287 is an additional remedy needed to prevent the future sales of these easily modified handguns. For these reasons, we request a favorable report. Thank you.
Mr. Chair. Whoa. Good afternoon, sir. Good afternoon, Mr. Chair, members of the committee. I am Anthony Barksdale, Deputy Mayor Public Safety in Baltimore City, here to testify on behalf of Mayor Brandon Scott in support of House Bill 1287. House Bill 1287 would prohibit the manufacture, sale, or use of any semi-automatic handgun that can be easily converted into fully automatic machine gun using an automatic sear. Last year, the Maryland General Assembly passed legislation to make it illegal to possess an auto sear, and this legislation will build upon the progress made in 2024. The changes proposed in House Bill 1287 will make Maryland's definition of auto sears more comprehensive, while also ensuring that the convertible pistol sale ban isn't overbroad and is narrowly focused only on Glocks and Glock-type pistols. Auto sears, often in the form of Glock switches, can convert basic firearms into illegal automatic machine guns that fire as fast as military-grade weapons. These attachments, which are easy to manufacture or simply 3D print, alter the trigger mechanisms of semi-automatic pistols to enable the continuous firing of up to 1,200 rounds per minute. We've taken additional steps in Baltimore City to continue the historic decreases in homicides and violent crimes, including filing a lawsuit against Glock Incorporated for facilitating the proliferation of illegal machine guns on the streets of Baltimore and Maryland. However, in order to achieve the greatest results, we must continue to work in partnership with the state to address all possible ways to further this decline. We need sensible gun legislation to protect Baltimoreans and Marylanders from the growing safety threat posed by convertible pistols. For these reasons, we respectfully request a favorable report on House Bill 1287.
Yes, sir. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. I'm Lieutenant Colonel John Herzog, and I presently serve as the Deputy Chief of the Citywide Investigations Division for the Baltimore Police Department. I'm here today to testify in support of House Bill 1287. Glock switches or auto sears can fire dozens of rounds in seconds, causing an extreme risk to the public and to law enforcement. In fact, once installed, Glock switches allow pistols to fire up to 1,200 rounds per minute. What that means is that one single trigger pull with a modified Glock can put countless lives at risk. A notable incident involving a converted firearm occurred on October 3rd, 2023 at Morgan State University. 5 people were injured on campus, and the suspect used a gun equipped with a switch, making it exponentially more deadly than a regular firearm. These converted weapons put law enforcement at risk as well. In June of 2023, officers attempted to arrest Daryl Gamble, who fired dozens of rounds at police using a Glock 23 with a 51-round drum magazine and a conversion switch. In fact, 33 rounds were fired to be exact. He was able to unleash a rapid stream of gunfire, forcing officers into a dangerous gun battle in the middle of a busy neighborhood in Baltimore. Fortunately, no officers or citizens were struck, but this is an example of the danger switches have posed and currently pose to law enforcement. From 2023 to 2024, at least 100 Glock pistols converted into fully automatic weapons were recovered at crime scenes and during investigations, a number that has nearly doubled in the past year. Since the Baltimore Police Department began tracking the recovery of switches in 2023, 139 have been recovered. Again, the Baltimore supports this bill and believes HB 1287 will increase public safety and requests a favorable report to protect Maryland's communities and law enforcement. Thank you.
I'm going to hear from Aaron Earp, who's also testifying in favor of the legislation.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. And thank you for the opportunity to testify today in support of HB 1287, which, as you've heard, would prohibit the manufacture and sale of handguns, which can be easily converted into machine guns. My name is Aaron Earp, and I'm a senior policy attorney for the Giffords Law Center, and I'm also a resident of Calvert County. Prior to joining Giffords, I spent 8 years as a prosecutor and saw close up the effects of gun violence. This bill addresses a significant gun violence problem on the streets of Maryland. As the city of Baltimore and the state of Maryland stated in their lawsuit against Glock, quote, between 2023 and 2024, the city of Baltimore Police Department recovered at crime scenes and in connection with criminal investigations at least 100 Glock pistols that were illegally modified to fire fully automatically, end quote. When modified, these firearms are incredibly dangerous and difficult to control. More must be done to ensure Marylanders' safety. This bill prohibits only pistols which can be converted solely by the attachment of a switch. Attaching a switch does not require any special tools or expertise. And as you just heard from Mr. Lickenbrock, this bill does not apply to all semi-automatic pistols. In fact, switches are often referred to as Glock switches because they are specifically designed for use with that firearm due to the ease of which they can be converted. Other semi-automatic pistol models are not as easily convertible to automatic fire and would still be available for sale under this law. It's well known, and Glock has known for decades, that these pistols are being converted to machine guns, but they have chose to do nothing or little to nothing to make their products safer. They are endangering the lives of Marylanders every day, and these firearms should not continue to be sold in this state until they're redesigned. I urge a favorable report on HB 1287. Thank you for your time.
Questions? Delegate Phillips.
Thank you, Mr. Chair. And it's good to see you, Ms. Earp. I want to say thank you for your assistance last year on our gun accountability bill. What other efforts are being made across the country to deal with this issue? Very focused on this.
I know that New York recently made a change to their gun industry accountability law, I think, to clarify or at least make it easier to pursue lawsuits under that statute that would encompass design features like this, that had to do with like the danger of conversion to automatic fire.
So we're not the only ones looking at this from this perspective, is that correct?
That's correct.
All right, and this county high school kid can't resist asking a poly guy a question. I just got to do that, Mr. Chair. The Woodlawn guy. No, you've been in this business for a very long time, Deputy Mayor. Can you give us your perspective just on the devastation that you've seen over the years, specifically with this tool that's being used?
Sir, it's been a lot. Over my career, and even now, you tally it up, thousands of crime scenes. The majority are from handguns. And I've seen Glock and Glock-type pistols recovered over and over again by homicide or shooting detectives with bodies still landing on the ground. I've seen police-involved shootings, like the one that Colonel Herzog just described to you. I responded to that scene. And when you see that amount of rounds on the ground and the devastation that it can cause, it really makes you think about how much damage these weapons with the switches, with the sears can do. Sir, a lot of training, went to the range many years. I had to qualify with just a plain Glock. And even with that training, sometimes I might throw one round off here or there. But when you put on a switch like that and you're going from semi-automatic to full automatic, you really need training. You really need to know what you're doing with a weapon like that. And it's not the kind of weapon that you just want on the streets. And also, as a former police officer, Colonel is now still in uniform. Sir, that's something I don't want an officer or citizen to have to bump into.
Thank you.
Yes, sir. Thank you.
Billy Schmidt.
Thank you, Chair. I'm looking at the written testimony from Mr. Lickenbrock here, and it outlines the switches and the sears. Are they synonymous or separate in each other? Does anybody know, or does a switch or a sear the same thing, different things? Anybody?
I would say that a switch is a type of sear. I think
I would take them as interchangeable, sir, the definition.
Because I see one on the back of the gun here, but then I see one kind of inside the gun. So I guess it's hard for me to explain it to you with what I see here. But that was my question. If a sear or a switch were the same thing or different things. Thank you.
Thank you, Chair. Thank you, committee, for panel for being here. I keep hearing the 1,200 rounds per minute can be fired out of the Glock pistol. My calculations are that would weigh 27 pounds. Are there any clips that hold 1,200 rounds for the Glock?
Not that I have seen, sir.
Thank you very much.
Anyone else? Thank you all very much for testifying today. That concludes the testimony from this panel, and it should conclude the testimony for those testifying in favor. We'll hear from the unfavorable people testifying, including one virtual, not here yet. That would be Locke Michael Lay, who's virtual. Mr. Jocelyn, Mr. Pennack, Carla Mooney, and John Weber, if you want to come up. Mr. Pennack sat down first, so we'll hear from him for 2 minutes.
Thank you, Mr. Chair. Mark Penick, President of Maryland Show Issue. You have my written testimony on this matter. I will tell you what's the most troubling part about this bill is its ambiguity. It's very ambiguous as to what's being covered. Now, it doesn't say easily convertible or readily convertible or any other modifier like that. It says can be convertible. I'm here to tell you that every single semi-automatic pistol can be convertible. It's simply a matter of applying the tools and technology and knowledge to create something that's comparable to a Glock switch. A Glock switch is already a major federal felony, 10 years in prison. This body acted last year in HB 810 to make it also illegal, specifically in this state. But it also includes not merely the sale, but the transfer or offer for sale or the receipt, which means if I transfer my Glock pistol, and yes, I do have one, to my wife at the range, she's receiving it and I'm transferring, and I'm in violation of this statute. So the bill is sloppily written. It's overbroad, it's ambiguous, and it should not be adopted for that reason alone. You have the case law in Maryland is quite clear on this, but more importantly than that is that this bill is not going to have its desired effect of forcing Glock to change its design. Glock sells tens of millions of these over the years, so those simply leave Maryland. And that will mean that 60% of the police departments in Maryland that carry Glocks are not going to be carrying Glocks much longer because they're not going to be, Glock will not be in Maryland to service them. And they won't be able to buy them anymore, and they won't be furnished to the police. So there's going to be millions of dollars spent on replacement of those Glock pistols over time. So I understand that total aversion to Glock switches. I share that. But this bill is not carefully crafted to reach that end. Thank you.
Thank you, Mr. Chairman, members of the committee. John Jocelyn for 2A Maryland. The proponents have already admitted that Senate Bill 707 and House Bill 804 were failures. They've admitted that converting the pistol is illegal. They've admitted that the part is illegal. Yet somehow, House Bill 1287 is going to solve the problem. Easily convertible. That's a real buzzword. It's limited only by two things, the human intellect and the opposable thumb. We have the ability as a species to make tools and to craft tools. Firearm is simply a tool. What the bill doesn't address is who is going to review the 300-plus pages of firearms currently on the Maryland Handgun Roster Board, tear them all down to determine which one is or isn't easily convertible by some part that may at some time on some date be designed to fit that particular pistol. This will be a massive undertaking and the bill does not address it. Even if this bill passes, it will make these switches and Glock pistols just as hard to find as cocaine. What it will do, it will be a boon for the traffickers. They will still be making their homemade Glock switch. They will still be trafficking firearms. They will make the pistols, even if Glock converts their design, it will make the old pistols more desirable. There'll still be replacement parts to put in those old pistols. And the only real beneficiary is going to be the people who make the Glock switch illegally, who transport and traffic, and the people who steal the firearms and transport and traffic the firearms. It will not make us safer. This is a political exercise. It's not a serious effort to make our streets safer. We ask for an unfavorable report.
Chair Clippinger, members of the House Judiciary Committee. My name is John Weber, and I represent the National Rifle Association and our members in Maryland. The NRA is opposed to House Bill 1287. This legislation seeks to ban pistols that can be converted to fully automatic firearms. While we share the goal of reducing crime, this legislation is deeply flawed and overly broad. The devices commonly known as auto switches or Glock switches, which illegally convert semi-automatic firearms into fully automatic ones, are already prohibited under both federal law and Maryland law. The NRA supports the enforcement of these existing laws against criminals who use or illegally possess such devices. However, this bill takes a different approach by targeting handguns, specifically pistols that could potentially be modified with an illegal device. This is an important distinction. Virtually every semi-automatic pistol can, in theory, be modified with an illegal auto switch. including 3D printed ones with limited tools. The ATF has recovered models from SIG, the P320, and Smith & Wesson M&P models, as well as Glock switches. This bill does not purely target Glock. Those are 3 of the most popular handguns in the country. These devices are often 3D printed or smuggled from places like China, are small, inexpensive, and designed to exploit the basic mechanisms of semi-automatic polymer striker-fired weapons. Banning handguns that can be converted bill risk outlawing an entire category of firearms. This is not a targeted solution. It's a sweeping approach that could strip Marylanders of their constitutional rights to own some of the most common and reliable firearms available. Considering the device is already illegal, we should focus on enforcing the laws we have. Target the traffickers of these illegal devices, crack down on criminals who use them. Don't punish law-abiding Marylanders by banning tools they rely on for lawful purposes. We respectfully urge an unfavorable report.
Good afternoon. Thank you, Chairman Clippinger, for allowing us to speak today. My name is Carla Mooney from District 29C. I'm the representative for Women for Gun Rights in Maryland. I came in for this bill really specifically to say that I am for the safety in our communities. I am for self-defense for each person in the community. I believe that if the laws that are on the books currently, which include the auto sear device that has been talked about, if those laws were enforced, it would help prevent the crimes that happen in our communities. Let's work on going after the criminals who use illegal devices rather than everyday citizens who use tools to protect themselves and to save their own lives. This is just one of many attempts to find another way. You've already got bills on the books that would work if they were actually given the proper consequences. This is all I have for this bill, is just to please go after the criminals, not law-abiding citizens. Firearms are tools that we use to defend our lives every day. Thank you.
Right, questions? Delegate Grammer, directed to one person, please.
Thank you, Mr. Chair. Question for Mr. Jocelyn. They mentioned mag disconnects. Can you comment on that and how that would be relevant to Glocks?
The magazine disconnect is a feature that precludes firing the pistol when the magazine is not present in the pistol. The problem with those on a defensive pistol is that if you have to do a reload and you've taken the magazine out but still have one in the chamber, you're now vulnerable until you manage to strip out the empty magazine, place the loaded one in, and then rack the slide. So you're far safer as a citizen, as a law enforcement officer, being able to do what we call a hot reload in a very stressful situation so that you are not vulnerable during the period of time it takes you to make that magazine change.
Can I have additional questions? Okay. Mr. Pennack, so the switches are illegal. Have you ever seen a bill that actually banned a gun based on its ability to be modified with an illegal device?
No, this is the first, and this is the first nationwide.
Cool.
And bear in mind that Maryland law has never held manufacturers responsible for the criminal misuse of third parties to whom they do not bear any special relationship. So this would be a huge departure from Maryland law. That case law is in my written testimony if you want to look at it. So this is the first time. It's like holding Ford responsible for having a car that could be souped up to make it fast get away from robberies, and banning Ford from being sold in Maryland because of it. I mean, Glock is not responsible as a matter of law for the criminal misuse of its products. You do have to modify the frame of these pistols. You have to cut a notch into the frame. On Glock pistols, that notch is in metal. It's not simply a matter of throwing on a black switch on the back of a slide. So you simply have to be able to modify the pistol correctly in the right place. Now, is it hard? No. Can people do it? Sure. But it's not a design of the Glock's pistol itself. It is a frame modification. You see a picture of that in my written testimony on the back of it where it has a Glock switch. So I don't know of any precedent for this. Not even in California has attempted this kind of.
And finally and briefly, I don't actually know the answer to this question, but for the gentleman at the NRA, I get the feeling that the breadth of this ban is likely much greater than just Glock. Can you comment on that?
Yes, as I mentioned, the ATF has recovered pistols from Sig Sauer and Smith & Wesson that have small 3D printed switches such as these. I think it is something that can be done to most striker-fired pistols, which are the most common pistols sold in the country today, most commonly used by law enforcement. So again, it's not specific to Glock. ATF has recovered and has reports on pistols from multiple other manufacturers with these modifications.
So, and I just want to be clear on that. It's not specific to those 2 or 3 brands. It's likely most pistols.
I'm not an engineer, but it seems to be something that anything that is striker-fired can be modified in this way, and so I would read this as a ban on striker-fired pistols in Maryland, not on Glocks.
Okay.
I would go even further, Delegate Grammer. I've seen switches installed on a Browning high power, which was first introduced in 1935. It's a hammer-fired pistol, not a striker. The same thing on a Colt 1911, which was introduced in 1911. So there's really no end to the technology that can be used to convert a handgun, a semi-automatic handgun, into a full auto.
Also the Beretta 92 FS, which again is another older model.
Okay, thank you.
Thank you, Mr. Chair. I guess this is a question for whoever made the comment about the language that it can be concealed.
That would be me.
Okay. So the obvious follow-up is, would it please you if it said can easily be concealed, as you suggest?
Well, the problem with that is the definition of easily, because I don't know what that means, and most people, manufacturers, are not going to take the chance on marketing something that can be open to multiple interpretations and bad facts. So I don't know, I can't suggest to you language that would make that more specific to Glock or Glock clones without specifying exact models in which you're trying to achieve. But right now, it can be.
There's a world, though, isn't there, where I guess a known design defect in the product liability world does, at some point, the knowledge of it and the ease of it prompt, seat belts, for example. There's a whole legacy of this kind of law. But I guess the reason I bring it up is I'm struck by one thing you said, which is it would be unusual for third-party liability for firearms manufacturers for crimes. But is it not the case that we do have 2 at least tangential examples in Maryland, the handgun roster board and Saturday night specials, and again, fashioning some policy solution to get at a gun manufacturer who knows or should know that their device is being used for crime? It might be marketed. Specifically in that instance, it was being marketed for that. And that's the handgun roster board. And the second is Polymer 80 and the civil litigation where they basically conceded that they were flooding the market and it was known to be used in crime in the greater Baltimore region. So I guess what would be your response to that, whether these provide some example as to Maryland stepping into this territory?
Well, it's interesting you should mention the roster board. Glock is on the roster, so are all the clones. So is the Browning high power, the Beretta, and the Colt. So they've already found those safe to operate under the criteria used on the roster board. As to the Polymer 80, that was the main problem with the Polymer 80 was that it's a so-called ghost gun, doesn't have a serial number, which was thought to pose a particular, you have already operated.
But in both situations, were not the Saturday night special manufacturers and the Polymer 80 manufacturers being called to account through policy changes for what third parties were doing with their products?
It's theoretically, yes, but the criteria are different.
I get that it's different, but there are examples of this in Maryland.
Yes, but not sort of barring manufacturers from the entire market. The roster board perhaps would be the exception, but the criteria for that on the roster board are much different than whether or not it can be illegally modified by a criminal using illegal parts to manufacture a gun which would be illegally multiple times over. That's part of the roster board criteria.
I understand, and I guess I would suggest, isn't it possible that, again, if it's easily an easily fixable design issue, then we're in safer territory requesting this policy change.
Any source of limitation that you can place on can be would certainly be an improvement in the bill, because can be means possible.
Okay, thank you.
Delegate Tomlinson and Phillips. I think we're going to move on.
All right. Thank you, Mr. Chair. This question is for Maryland Shall Issue. I don't know if you got, State Police, I don't believe they're going to be testifying, but they submitted information only. Did you get a chance to look at their testimony by any chance?
I've not seen their testimony. I know the state police do in fact carry Glocks, and as do many other police departments.
Yeah, and there was a little bit I believe during the sponsor's testimony, she spoke a little bit about the about how it will or won't affect the state police, but they wrote that manufacturer in another state could still manufacture semi-automatic handguns, but would be barred from transferring them into Maryland. Semi-automatic pistols could not be transported across state lines by delivery vehicles to be handled by federal firearms licensees or distributors licensed by the federal government. Future replacement pistols for the Maryland State Police or other law enforcement agencies could not be purchased or shipped to the agency. Repair facilities would be prohibited from accepting a semi-automatic pistol for repair. Based on how the bill is written now, does that sound about accurate?
That's exactly accurate.
So this would affect law enforcement?
Well, of course it would, because even though there's an exception for sales to law enforcement, Glock's not going to be in Maryland just to sell to law enforcement. If they can't sell to anyone, they're probably going to withdraw from the market. So all their future sales with respect to law enforcement are going to be affected. So think about swapping out all the officers with Glocks into something else that still might be subjected to this bill, because again, can be means everything.
Gotcha. Thank you.
Mr. Pennick, you made a comment, and I want to just kind of use the scenario and make sure from a legal perspective. Hyundai and Kia were liable for design flaws which made their vehicles more susceptible to theft. I liken this to Hyundai and Kia. We have a design which made itself more likely to have a illegal device used. Do you agree or disagree?
I'm not sure I do, Delegate Phillips, because I don't think any of those suits against Honda and Kia in particular, ever went to judgment. I think they were all settled. And Kia basically caved on it and modified its vehicles to have those devices. So I'm not sure that's an apt example, other than litigation being used to force design that manufacturers heeded to. And that's, in my view, not a particularly model that Maryland should be adopting as litigation as lawfare.
The litigation worked to modify what was a significant nuisance with thousands of vehicles that were being stolen that impacted communities around the country.
I understand that.
Maybe this would work the same way. Thank you, Mr. Pennick.
Seeing no further questions for this panel, we thank you all very much. All right, so several things changing in the lineup here this evening. House Bill 1392 from Delegate Long is going to be, is going to be moved to Tuesday, next Tuesday, as Delegate Long has a pre-existing appointment that he has to keep. And he is away from the General Assembly right now, so we're going to reschedule it to next Tuesday. Delegate Acevero's bill is going to go next because Delegate Hornberger is in a voting session. So we're going to get to House Bill 1394 next. However, members of the committee should know that House Bill 916 from Delegate Ampry has been withdrawn. Delegate Crosby's House Bill 928 has been withdrawn. And House Bill 1188 has been withdrawn. So we've had 3 bills become withdrawn here. So we're moving right along. And one moment, please. Yeah, we're going to go, Okay, so Delegate Acevedo now is in the midst of asking a question in the Appropriations Committee. I'm sorry? Yes. Yeah. I could, I'm looking around the room to see if I can do my bill, which might not take an incredibly long time. But who knows? But I want to be, well, we're looking for Hinton, Silverman, and Collins. There's Mr. The 3 withdrawn bills, 928, 916, and 1188. 916 wasn't on the list. Yeah, it's on the list. Oh, there it is. All right. So what we're going to do, to give Delegate Acevedo time to come here, I'm going to call my bill to maybe kill a little time. House Bill 1099 is my bill. It has a somewhat interesting history, but Delegate Acevedo does, but he's in appropriations. Point of order?
It wasn't on the list. It didn't make the hard copy.
Yeah, so, okay. Going all the way back. So what happened was this. When, for reasons we don't understand, Delegate Acevedo's bill got knocked off the hearing list that was put out apparently yesterday. And we're not sure why, but the people who signed up for the bill still were signed up, and we are going to hear the bill today. We're not sure why it was knocked off the list, but it was. So we are going to hear that bill, House Bill 1394, here in a moment. But for now, I'm going to ask, I think it's Mr. Chawley, to come up, who is favorable with amendments, and we're going to do House Bill 1099. House Bill 1099 came from a discussion from myself and the chair of the Appropriations Committee, who members of the committee will note is the second on this bill. There's a couple issues here that are going on with the bill. One, there is a desire, I think, to have a conversation about, and I want to stress conversation, about the definition of what constitutes a punitive damage, what constitutes punitive damages. And so in the bill, there is a different definition to punitive damages, and I believe that Mr. Tolley will be able to speak to what the existing definition is and talk about the changes that the bill would make. The other thing relates to, and it's at this point that I get to recognize the Chief of Staff for the committee, Hunter Marsh. There are several states that have elected to tax punitive damage awards and have money go to their general funds. Delegate Barnes and I were speaking about that, and him saying, hey, these are punitive damages, not economic or non-economic damages, and so why don't we consider perhaps taxing those? In a conversation inside the committee, perhaps with possibly the vice chair, but definitely with the chief of staff, he came up with the idea, why don't we not tax the person who was injured, but seek to create a surcharge on top of the jury's award of punitive damages. So part of this is Hunter's fault. And so we're not sure that part is even possible under the law, but we decided at least to take a spin at it and to see what that looks like. The main reason for House Bill 1099 is to have a conversation about the definition of punitive damages. And so we're going to do that right now. And with that, we'll go to Mr. Tolley, and then there are 3 people signed up in opposition. and we'll go from there. Mr. Tolley, please, for 2 minutes.
Thank you very much, Mr. Chairman, Madam Vice Chair, and distinguished members of the House Judiciary Committee. Is this on? Yeah. So we've been having a conversation this session about non-economic damages, you may remember. Non-economic damages are compensatory damages that are included in a jury's verdict if the jury finds that the defendant was negligent and the negligence caused harm, and that harm included emotional anguish or pain or suffering of some kind that's not medical bills and lost earnings. Non-economic damages and economic damages are compensatory damages intended to compensate the plaintiff, essentially putting the plaintiff using money back in the position the plaintiff would have been in if the negligence had not caused harm. We don't do eye for an eye. We use money to compensate plaintiffs. We don't make the defendant cut their own leg off or things like that. Punitive damages are a centuries-old form of damages that can be included in a jury's verdict under certain circumstances. They are not intended to compensate the plaintiff. They are intended to be a kind of punishment for conduct that isn't merely negligent, but goes far beyond that and can be characterized in a host of different ways. There are 50 states and probably 41 different ways to describe punitive damages. Essentially, it's common is gross negligence or reckless disregard for the rights and safety of the public. Punitive damages are a particularly effective way for juries to punish reprehensible corporate conduct because corporations can't be put in jail, right? If an individual intentionally harms someone, there's a criminal law consequence for that, but not for corporations. And that's where you see punitive damages, particularly. My 2 minutes are up, so I will happy to answer any questions about punitive damages.
Mr. Tolley, can you talk more about the definition of what constitutes a punitive damage now and how the bill would change that?
Certainly.
In about 2 or 3 minutes.
What I'll try to do is refer you to the written testimony. I submitted a written report that was produced by a House work group back in 2016, 2017, which is the last time punitive damages was a subject of conversation in this body. It includes a lot of research about what the standards are, what different states do. Punitive damages generally are not common, but they're not rare either. The statistics I've been able to find, although there's not a lot, show that a punitive damages claim will be included in about 10 to 12% of cases that go to trial that are civil cases. And as the chairman pointed out, in some jurisdictions, punitive damages are taxed because the idea is this is a sort of penalty and the plaintiff shares the monetary penalty paid by the corporate defendant with the state because it is a public kind of punishment in a court of law, but the plaintiff in the shoes of a private attorney general or something you can think of that way is the one who brought the case and identified the conduct and proved that it was reprehensible by whatever standard the state applies. That's punitive damages. In Maryland, the reason there's a bill is because in 1991, our now Supreme Court decided to adopt the narrowest standard in any state for punitive damages, actual malice. You must prove that the defendant's conduct was motivated by ill will or malice toward the plaintiff personally. And that takes corporate wrongdoing right off the table because corporations don't manifest that kind of malice towards individual people typically. So it's a combination, and there were conversations with some of the delegates on the money committees that punitive damages is a source of revenue in some states. But if you're going to tax punitive damages in negligence cases in Maryland, you'd be getting 50% of zero because there really as a functional, practical matter, no punitive damages are recoverable in negligence cases. There's a different standard in punitive damage, or in product liability cases. There are a different standard in defamation cases, for example. Those aren't really negligence. Does that answer your question?
Yes, thank you very much. Delegate Cardin, then Embry.
Thank you, Mr. Chair. Thank you very much, George. First of all, my understanding is that actual damages are compensatory damages. Well, the damages you were talking about, compensatory, but non-economic and economic. Punitive damages are not meant to compensate the plaintiff. I'm reading from the fiscal note. Rather, they're designed to punish or deter blameworthy behavior. Is that fair? Is that correct?
I'll agree with every word of that.
Okay. So it's not as essential where those damages go, or is it?
You mean the punitive damages?
The punitive damages.
The punitive damages are not intended to compensate the plaintiff. I think the plaintiff gets a share because the plaintiff is the one that brought the case and proved it and went to the time and trouble to prove it. But that's the justification for taxing it in states that do so.
So it's not that it's essential that it goes to the plaintiff at that point. It's essential that it's punishing the defendant, but not that it necessarily wholly goes to the plaintiff. Is that fair to say?
I'll agree with that.
Okay. Is it, however, according to the fiscal note, and you can correct me if I'm wrong because you do these kinds of cases, if you're seeking punitive damages and the jury is going to decide them, they are not allowed to know that a tax or a surcharge may be put on. Is that correct?
So first, I don't do these kinds of cases. I passed the bar in 1992, the year after the Zenobia decision took them off the table. And so I've only ever had a punitive damages claim when I've had a case in a different jurisdiction. That said, juries, so there are controls.
In the bill, though, in the bill, it specifies that juries are not allowed to know that this surcharge can be put on it.
And I can't say that that's always the rule in every state where the tax exists.
But in this legislation, that would be the case if we passed it as is.
If you passed it as is, that would be the case.
If we're not trying to necessarily reduce the amount that's going to a plaintiff because the amount that goes to the plaintiff is not essential, why should we use that policy?
I don't have a strong opinion one way or the other about what the jury is told about where the punitive damages money goes. Candidly, though, punitive damages are often subject to trial court supervision, just the same way any non-economic damages might be subject to remittitor, so can punitive damages. There are constitutional elements to that review, including due process, because you can't, under the Fifth Amendment, punish in a way that, I think it's the Fifth Amendment, or maybe it's the 14th Amendment. But so there are reviews, so you can't really honestly tell the jury that whatever they put in their verdict, half of it goes to the state. That's after maybe several levels of review.
And in layman's terms, last question is, a judge could, in theory, reduce what the jury
100% true.
What the jury suggests, and then and judge certainly knows that there might be a surcharge or a tax. So they could be accounting for that as well.
The judge would know the law.
Thank you, Mr. Chair.
Delegate Embry.
Thank you, Chair, for this very interesting bill. I wonder if you could, I have two questions. One is if you could talk about how the definition of gross negligence, where that came from.
Sure.
Based on, and then second, if you don't mind, is there any precedent for this in state law or?
Oh, so, all right. So the first question is where did gross negligence come from? In the written report of the House Work Group, and I was actually one of the people on the House Work Group back in 2016. I was chaired by former Vice Chair Kathleen Dumais, who's now on the bench. There was a study of what is the standard for punitive damages in all 50 states, and a plurality of there are 41 states that allow punitive damages, excluding Maryland and North Dakota, which have the narrowest, so 43. And then there are 7 states that don't allow punitive damages. They're not allowed. Overwhelmingly, most of them, and many of the ones you think of as pro-business jurisdictions like Texas and North Carolina and Tennessee, Oregon, Missouri, Indiana, they're all gross negligence or reckless disregard. The thought was to make it gross negligence that is clear and allows for, in language that a jury can easily understand, and give them different options depending on what kind of case and what kind of conduct it is. So each one of those, first of all, you have to have conduct that the actor knew was likely to cause harm, and you have to prove the standard by clear and convincing evidence. That is the law in Maryland, according to our Supreme Court, and it's the law in many other states too. It's not just a preponderance of the evidence, it's a higher standard, but not quite reasonable doubt. And lastly, it's an attempt to define gross negligence in this context in a way that mirrors standards that other states already use, so that we can look to those states, and any judge can look to those states to see what the standard means, so we're not writing on a blank slate. But that also, in a meaningful way, defines how that conduct is different from simple negligence, because it has to be. Does that answer your question?
Yes.
And then the second question was, is there precedent for this?
Specifically.
Oh, well, the surcharge, I don't know where that came from. I wasn't in that room.
Thank you.
We're going to let Hunter look that up.
And so I'll defer to staff counsel for that.
Thank you very much.
Thank you.
Delegate Taylor.
Thank you, Mr. Chair. Thank you, George, for being here and trying to help us make sense of this. So, you mentioned that in some instances, punitive damages are taxed. Now, I know we just kind of had a conversation about that, but can you give me an example of how that would work? So, because I'm getting the sense that punitive damages don't equate really to money. And I guess then there's a follow-up to that is, if this is a surcharge, upon what is the surcharge calculated?
Okay, I'll defer the second part of that question to counsel. But on the tax question, it's a great question. When I represent an injured person and obtain a settlement or judgment for compensatory damages only, that is not treated as income under the federal income tax code. There's a section 104A2 that says that money paid on account of physical injuries or sickness is not included in gross income, and therefore it's not subject to income tax.
So the recipient is taxed?
The compensatory damages.
Okay.
Punitive damages is not excluded from gross income and is taxed federally. It's already subject to tax. When we settle cases, we typically include language in the release that the defendant requests that says no part of this is punitive damages. So punitive damages can be taxed and is taxed. If you get punitive damages in a defamation case or an employment a discrimination case, you can expect that part of the award will be taxed in some way. So just generally, it can be taxed. The special tax, the particularly, not at 50%, but 50% tax isn't an income tax in the bill, or at least the way it was originally drafted wasn't going to be a 50% tax. That's a tax where the state is sharing, essentially, the punitive damages recovery. And the average punitive damages statistics that I've been able to find, at one point, the last time the Bureau of Justice, the Department of Justice reported data was 2005. The average punitive damages award in a case was $64,000, give or take. So they're not huge numbers,
Nice.
at least then. I expect some of the folks coming behind me are going to tell you that punitive damages awards are much, much higher today.
Sure.
And if that's true, that just means the state would get more money. As far as why they're larger, I could talk about that if you care. But did I answer your question? It was
You
a good
did.
question.
Part two
Surcharge.
is, so okay, to be clear, the main reason for the legislation was to have a conversation about changing the standard in punitive damages. Whether they would be taxed or whether there would be a surcharge added on was partially part of a discussion that we were having here in the committee about whether it was right for somebody who had been badly wounded by, or badly injured by somebody, to have some of that, even the punitive damages, although it's supposed to be a penalty, whether it was right for them not to see every part of the punitive damage award and to further penalize somebody for a bad act down the road. That was the rationale about it. I think that Mr. Marsh is going to be writing his law school paper on whether this is even possible or not. So I would just drag the committee back to the reason that we're here. The taxing issue is one that other states have in fact looked at, but the bulk of the bill goes to the difference in the standards between what the standard is for punitive damages now and what it would be under the bill. Delegate Moon.
Mr. Chair, I wish I could help you get beyond that, because I'm still fascinated by the money. I'm not gonna lie. But let me ask just a couple of questions here. This bill doesn't cap the punitive damages?
So I hearken back to the hearing on House Bill 113, where the opponents to eliminating the cap on non-economic damages emphasized that Maryland has never capped punitive damages. And so that's true. There is no cap on punitive damages in Maryland.
Okay, and I guess I'll just say on that, I don't feel so bad about the jury notice issue, since we don't warn about the caps either. And again, if you'll just indulge me on the money bit for just one more second, did you do any back of the napkin math kind of exercise to try and estimate it all? If we just did the states that do gross negligence, punitives, just any kind of percent of caseload or something that gives us an idea?
So again, I'm gonna point to, in these numbers, a report of, and I can get you this report, it's easy to find online, that was published in 2011, but used data from 2005. It was a Department of Justice report that said the average number of civil cases that go to trial nationally, 12% of those trials included a claim for punitive damages, and roughly 13% of those trials ended up with an award of punitive damages, the median of which was $64,000. If you assume that Maryland is 1/50th share of all those trials, it worked out, if I remember my numbers correctly, to something like between $2.5 and $5 million a year. Now, those are old numbers. They're 20 years old.
That's the amount of the damages,
That's
not
the
on
half,
the surcharge.
that's the 50%. That's the, of those, if you add up all those punitive damage awards, with the median being the one in the center. And I suspect that the median doesn't fully disclose how big those numbers can be, because even in the 1970s, there were punitive damages awards in the hundreds of millions of dollars. When Ford famously was held liable for marketing the Ford Pinto, which would blow up if you rear-ended it, the punitive damages award in that case was over $100 million, and that was in the 1970s. So they can happen. And if there were a very large punitive damages award,
we just couldn't count on solving the budget deficit in that manner in the near run.
You'd have to, there are things you'd have to do before you would expect that would happen in Maryland, yeah.
All right, thank you.
Very brief, Mr. Chair. Medical Mutual says that it will greatly destabilize the medical personal liability market, because they say rates are stable right now. And so I just wondered if you had a response to that.
some medical professional liability insurance premiums are stable. In fact, I think the data is, and MedMutual publishes its rates. Those are published by the Maryland Insurance Administration every year, and the rates are cheaper now than they were 20 years ago. And not much in healthcare. It's cheaper now than it was 20 years ago. So I agree with MedMutual and MedChi in that regard. Whether punitive damages, it's easy to avoid punitive damages, it seems to me, is just don't act reprehensibly, and then you'll be okay. And additionally, the same argument about bad faith, the same arguments about insurance, all those same arguments are still just as good if punitive damages is part of the picture or not. The insurance industry has a responsibility to protect its insureds against excess verdicts and to settle cases within policy limits where that's possible. And so I respectfully disagree. I think if there's an effect, I will grant them this, that it's about time the standard insurance coverage in medical professional cases is more than $1 million. That has been the case for 50 years. It really should be maybe 2, and that might be incrementally more expensive. I don't think it'll destabilize the market, though.
Thank you, Mr. Tully.
Thank you.
Thank you very much. That concludes the testimony in favor on the bill. We're now going to go to Bob Enton, Carrie Silverman, Carville Collins in opposition. I'd ask them to focus mostly on the change in the standard, unless they have strong feelings about Hunter's idea about a surcharge, but want to focus mostly on the standard, please. Delegate Acevero is here, so we're ready to get back to regular programming as soon as this is done. Please, Mr. Collins.
Thank you, Mr. Chairman. Madam Vice Chair, members of the committee, I'm Carville Collins, here on behalf of Maryland Employers for Civil Justice Reform Coalition. We're here in opposition. We are comprised of many of the largest employers, businesses, and healthcare providers in Maryland. You have our written statement and that of an array of other organizations who have submitted written testimony only, healthcare providers and their insurers, the Chamber of Commerce, the transportation sector, the defense bar. To the main point that you've asked us to address, Mr. Chairman, it is long settled law that the standard for the award of punitive damages in Maryland is actual malice. This means that the trier of fact may not award punitive damages unless the plaintiff has established by clear and convincing evidence that the defendant's conduct was characterized by evil motive, intent to injure, ill will, or fraud. This current standard that we live by today, we submit, is appropriate. It is an extraordinary standard because punitive damages, which are unlimited in Maryland, are an extraordinary remedy. The Supreme Court of Maryland, and back in the day, of course, it was the Court of Appeals, explained why the lower standard of implied malice or gross negligence, which had been the standard for just a 20-year period, 1972 to 1992, was a mistake that needed to be overruled, and it was overruled in 1992. The court found there that, among other concerns, the implied malice or gross negligence standard presented the danger of a test which may be so flexible that it can become virtually unlimited in its application. The court further found that with that lower standard, the state of Maryland had experienced a literal explosion of punitive damage awards and practice under this lesser standard. So for those reasons, Mr. Chairman and members of the committee, we do urge an unfavorable report. I can also talk about some anecdotal information from other states that Hunter may encounter if you wish.
Thank you, Mr. Chairman. Robert Enton on behalf of the American Property Casualty Insurers Association, in very strong opposition, with all due respect to the chair, to this legislation. You know, it's very interesting. In getting ready for the hearing, I went back and I read the Owings, Illinois case, 1992. And what that case said, and this was a revolutionary case, because they looked at the standard for punitive damages And they decided that that standard was a very, very bad standard. And what they said was that the gross negligence standard, which is what this bill would put in place, and I quote, "The gross negligence standard has led to inconsistent results and frustration of the purposes of punitive damages in non-intentional tort cases." That's what your Maryland at the time Court of Appeals said. And it was an amazing holding because they really took the law and they significantly changed it. They also went on to say that because of the frailties of that standard, they say, therefore, we overrule Smith v. Gray Concrete Pipe Company and its progeny. In non-intentional tort cases, the trier of facts may not award punitive damages unless the plaintiff has established that the defendant's conduct was characterized by evil motive, intent to injure, ill will, or fraud, i.e. actual malice. And that's the standard we've had since 1992. It's a standard which has stood up year after year after year, and we see no reason to change it. And therefore, we urge the committee to give the bill an unfavorable report. Thank you.
Good afternoon, Mr. Chairman and members of the committee. I'm Kerry Silverman for the American Tort Reform Association, and we'd like to also express our respectful opposition to House Bill 1099. I've submitted written testimony, and if you'd like to take a look on our thoughts on the second part of the bill, I'll reserve that to the written testimony, which does go into that. The bill, as you know, will lower the standard for punitive damages, which are intended to be reserved to punish and deter truly reprehensible, malicious, wrongful misconduct, and it would change that standard down to a gross negligence standard. The Maryland Supreme Court has said over and over that this gross negligence standard, no matter how it's described, as in this bill, it has a considerable risk of just being understood as big negligence. That just means carelessness or extreme carelessness. And that's not what punitive damages they are there to punish. You've heard that other states may have a lower standard. I think that ought to be put in some degree of a national context is helpful. There are 6 states that do not allow punitive damages at all unless specifically authorized by statute. This is all my written testimony if you want the citations. There are also several states that have kept a relatively high standard similar to Maryland. I give some examples where courts have followed similar rulings in DC, in New York, in Maine. There are also several states that do so by statute. My testimony has a dozen of examples there. Now, there are some states that have lowered their standards, and that's caused problems. It's caused jackpot verdicts in those states. And what have they done? Half of those states have put caps on punitive damages to respond to the problems that were created by lowering the standard. You don't have that in Maryland, and this bill doesn't have it. Thank you.
Any questions from members of the committee? I have made light of Mr. Marsh, and he does an excellent job for the committee. We love him dearly. But we did have a long discussion about the back and forth related to the surcharge part of it, and that's why it's in the bill. So I don't want to be constantly giving him a hard time or make it seem like it's all his fault.
We love him.
That's right, we do. Delegate Grammer.
Don't let the chair lie. We all make fun of Hunter all the time. Just kidding. Wanted to give the gentleman an opportunity to talk about the data from the other states.
Thank you, Delegate. So it's anecdotal, just asked around, and what we've heard, Georgia does have a similar surcharge. The experience there is that the surcharge hardly ever is paid. Parties have ended up circumventing around punitive damages in settlement discussions, in resolution of cases other than in litigated results. And so the experience there, which Hunter, I think, will find anecdotally, is there's just not much in the way of punitive damages that are awarded in Georgia, and therefore the surcharge has been mostly meaningless.
Thank you.
One step closer to his paper getting finished. All right. Thank you all very much. Thank you all for.
Mr. Chairman, I was also a night student, so I feel for our hunter.
He's a night student. He's here, I'm sure he's not playing hooky tonight. All right, that concludes the testimony on House Bill 1099. Thank you very much. We'll go to Delegate Acevedo on House Bill 1394. Delegate Acevedo is coming up. We'll hear from him. We're going to hear from, I'm just going to go down the list if that is easier. We'll go Susan Karen, Ruba Abu Kadir, Zainab Chaudhry, Aisha Khatib, Reem Assam. Let's see how many of these people come up, and then I'll figure out if we still have chairs. Is Mr. Ali Saqib okay? Killian McGinnis? No? All right, those are the only two who are virtual. And we have a full table, maybe? All right, Delegate Acevedo, why don't you begin, and then we'll go from there, please.
Thank you, Mr. Chair, and I appreciate the accommodation by this committee as we were wrapping up our own hearings and appropriations. For the record, Delegate Gabriel Acevedo here to present House Bill 1394, which is a reintroduction. This bill is not new. It was introduced in the previous session, and a lot of what I cited as reasons or rationale for bringing the bill still stands today. But House Bill 1394, Not on Our Dime Act, essentially seeks to prohibit nonprofit organizations from knowingly engaging in or financially supporting illegal settlement activity in the West Bank, as well as Gaza, and the support for any auctioning of Palestinian lands here in the United States in accordance with international law and the U.S. Constitution. This bill signifies Maryland's alignment with international, federal, and state law that allows our Attorney General to pursue civil action and for the state to prevent special tax exemption status for any nonprofit that's engaged in or supporting the building of illegal settlements in Palestine and the auctioning or selling of those lands here in the United States. We have a moral duty to Maryland taxpayers. We're currently in a budget deficit. I don't need to let anyone know that. And as the people who are responsible for the judicious spending of taxpayers' dollars, we want to ensure that that is being placed in our communities and not being used by nonprofits to support illegal settlement activity. Last year, when I brought this bill, the opponents of the legislation brought up two issues, one being whether the bill was necessary because we had not seen any instances of whether it's auctioning of land, et cetera, in the state of Maryland, and the other being that the federal Department of State had policies that essentially sanction Israeli settlers and those who engage in this kind of activity. Today, sad to report that there was an auctioning event that was held in Baltimore last year. And in addition to that, with this new administration, the Trump administration, there has been a revocation of all of the sanctions and visa restrictions that are placed on individuals that engage in this kind of behavior. And so it speaks to not just the necessity of this bill, but the importance of us taking action. And my hope is that we don't have to come back here in future years continuing to talk about the theft, auctioning and selling of Palestinian land here in Maryland and across the United States.
Who would like to go next, please?
I can go.
Okay, you need to move the microphone in front of you, please.
Oh, sorry. Thank you. Assalamu alaikum and may peace be upon you all. As a Muslim, UMBC social work major, Howard County resident, and human being, I felt it was my duty to come here and speak on behalf of those oppressed who cannot. I'm so thankful for this blessed opportunity to come here and advocate for justice. I'm here to proclaim both my community's and my own strong support of this very crucial bill. This bill, if God willing is passed, will uphold human rights, enforce international law, and give protection to underprivileged, victimized communities abroad, all things that align with our Maryland values. Currently, Israel is acting in blatant disregard for international law by building illegal settlements on internationally recognized Palestinian land. This bill would prevent Maryland nonprofits from financially aiding in such illegal settlements, thus ensuring our state of Maryland does not contribute to the breaking of international law. My Prophet Muhammad, peace be upon him, teaches us that the believers are like one body. When any part aches, the whole body aches. In February alone, Israeli settlers backed by Israeli military forces conducted 1,705 attacks on Palestinians on the West Bank. We should pass this to uphold the Geneva Convention and align our values with it as well. Thank you.
Thank you very much. Who'd like to go next?
I can go, thank you. Good afternoon, Chairman and members of the Judiciary Committee. Thank you for the opportunity to testify in strong support of House Bill 1394. I'm speaking on behalf of the Maryland Office of the Council on American Islamic Relations. HB 1394 represents a critical step toward ensuring that Maryland's laws align with our state's commitment to human rights, justice, and national and international legal standards. The bill reaffirms that nonprofit organizations, which benefit from public trust and tax exemptions, must not be complicit in perpetrating human rights violations or acts of violence against protected persons in the occupied West Bank, including East Jerusalem. Palestinian communities in the occupied West Bank face alarming rates of violence, forced displacement, and the destruction of homes, schools, and essential infrastructures at the hands of Israeli settlers and military forces. This legislation provides essential accountability by empowering the Attorney General and harmed individuals to seek injunctive relief and damages from nonprofit organizations. Thank you for your time and consideration.
Good afternoon, Ruba Abu Khadir, Chair and members of the committee. As a Maryland resident and a firm believer in human rights and accountability, I support HB 1394 because it ensures that nonprofit organizations operating in our state are not complicit in funding or facilitating human rights violations. This bill sets a necessary standard that organizations benefiting from our tax system should not be aiding actions that violate international law or harm innocent civilians. For too long, we have seen nonprofit organizations act as financial conduits, providing material support to entities engaged in the displacement and oppression of Palestinian communities. This is not just a distant foreign policy issue. It's a moral and ethical concern that directly involves Maryland residents and values. HB 1394 is not about silencing anyone. It's about holding organizations accountable for how they operate under our state jurisdiction. By passing this bill, we reaffirm our commitment to transparency, human rights, and the responsible stewardship of charitable funds. So I urge you all to support HB 1394 and ensure that Maryland stands firmly on the sides of justice. Thank you.
Thank you. Please.
My name is Susan Karen. I was spit on once in my life. Spitting on someone is a rather intimate act of aggression because the person is putting their bodily fluids on you and they have to get real close to you. You look directly in their eyes. However, the person who spit on me didn't spit on my face, and the reason is he was a 6-year-old and didn't have the reach. He was an Israeli settler child, and I was in Hebron, Palestine, as part of the Christian peacemaker teams. The CPTers walk Palestinian children to school to protect them from adult settlers and soldiers who often harass them or prevent them from getting to the school doors. I was just spit on, but another CPTer from Silver Spring, Maryland, Kim Lamberty, was beaten by adult settlers with bats because she was escorting children to school. The reason I'm telling you this is so that you have a close-up, real-life understanding of settlers. They are ideologically rabid, violently cruel, and racist, and they have influence within the political system inside Israel's borders. I urge you to request a favorable report.
Committee, normally, if this were a new bill, people would get 3 minutes to testify. The sponsor would get 3 minutes and everybody else would get 2. It is a reintroduction, and so by the committee's rules, we go with 2 minutes and 1. We gave Delegate Acevedo the 3 minutes, and then we realized that it was a resubmission. That's why you all got 1 minute. With that, we will take questions. Delegate Phillips, please.
Thank you, Mr. Chair. I'm trying to understand how this works. And Delegate Acevedo, you mentioned auctions, and you talked about Baltimore. Could you elaborate? I'm not sure I understand actionably how this works?
Yes, Delegate, I appreciate the question. Last year, there was an event that was held at, from what I understand, the Pikesville DoubleTree that was essentially auctioning off land, Palestinian land. And there were a number of protesters who disrupted that event. But when I brought this bill last year, that was one of the questions that was raised by a member of this committee, is whether there are instances, right? I guess the member was trying to get at the need for the bill and if there are any instances. And so at the time, we were not aware of any instances of, the building of illegal settlements and the auctioning of Palestinian land happening in the state of Maryland. But over the summer last year, there was an event that was held. It was an exclusive event. It's not an event that was opened up to the public where you, I, or any other member of this committee can show up and purchase a home or land. It was an exclusive event. It was held at the Pikesville DoubleTree, and it was specifically for the auctioning or selling of Palestinian land in direct conflict and violation of not just international law, but U.S. law. I mentioned in my testimony earlier that the Department of State had policies that essentially would hold settlers and individuals who engage in the building or selling of illegal settlements accountable in the form of sanctions, in the form of visa restrictions. This new administration, the Trump administration, has since repealed all of that. So if this were to continue to take place, there will be no kind of accountability at the federal level for individuals who steal Palestinian land, who build illegal settlements, who work with nonprofit organizations to then sell or auction those lands off to individuals here in the United States. There would be absolutely no accountability. And I would also point out that that was something that was done by the Biden administration. They had, put these very strict policies in place in accordance with international law. And so with that being repealed, I wouldn't be surprised if we see just an uptick in auctioning events like what we saw last year in Baltimore. So when I referenced that in my testimony, that's what I meant. There was an actual event that was held auctioning land last year in Baltimore.
Okay. Thank you.
Delegate Pasteur. Thank you, Mr. Chair. Delegate Acevera, you've mentioned illegal settlements in your testimony. Can you give us some more detail about, and I'll use the Pikesville event as an example, who is deeming what territory that is somewhere else as illegal and executing this kind of activity in Maryland?
Yeah, I don't want to get too, and I'll be very brief, I don't want to get too wonky into foreign policy, but essentially the International Court of Justice had ruled that the building of settlements, whether it's in the West Bank or in Gaza, were not just illegal but needed to cease. This is not just an ICJ ruling, it is the determination of a number of international human rights organizations. And so to have nonprofit organizations, to have individuals who are involved and just flagrantly disobeying U.S. and international law, I think it's just unacceptable. And anyone who advocates for that, who makes excuses for that, you really have to ask them the question whether they support not just the displacing of Palestinians, but really the theft of Palestinian land. And the selling of it, and that's the real question here. This is not about any one particular group or any one particular country. This is about a commitment to a two-state solution that was already decided at the international level. We want to make sure that folks are being consistent with that.
Okay, so you're talking about groups and individuals that are
correct. And so to answer your question, it was the International Court of Justice. So when I say illegal, the basis for that is an ICJ ruling.
I'm sorry, the basis is the Geneva Convention, which if you occupy a territory, you're not allowed to move your people in it or to displace other people. So it goes back to that original.
Thank you both.
Yes, and I will be brief, Mr. Chair. I have two brief questions, and that is, are you at all concerned, Delegate, about, because whether or not we can agree, whether or not we agree that people should be living there, are you at all concerned about collateral consequences such as a nonprofit organization builds a PT clinic for people with a physical therapy clinic for people with cerebral palsy that live in the settlement, and under your bill, the nonprofit wouldn't be able to build such a thing. So are you worried about collateral consequences? And also, again, we can agree to disagree, but personally speaking, I think that there are a lot of different countries with questionable records on human rights. So why did you choose just to focus on Israel? Because there are numerous countries that I think you could have focused on.
Thank you for the question, Delegate. I am not concerned about collateral damage because, one, it is the responsibility of every nonprofit to ensure that they are in compliance with or in adherence to whatever the laws of the state or the country that they're operating in. And so if we were to pass this and it were to be law, then it is the responsibility of nonprofits to ensure that they're adhering to that. My hope is that there would be no nonprofit that would be involved in actions such as this, where Palestinians are being pushed off their land, they are being pushed out of their homes, and their lands are then being sold to individuals here in the United States. So my hope is that no nonprofit would be involved in that, and if they are, then this serves as notice that this is not something that we tolerate here in the state of Maryland. And we will certainly, do what's necessary. Now, to your second question around like the human rights records of other countries, I'm not talking specifically about the human rights record of any country. I'm talking about the policy of moving Palestinians off of their land, building houses, and then selling those houses here in the United States to non-Palestinians, effectively what I would consider to be ethnic cleansing. We are not talking about the human rights record, rather a specific policy of the Israeli government. And I'll also note there's no other government in the world today that is doing what Israel's government is doing right now as it relates to settlement and the theft and auctioning of land. When we passed the Ukraine resolution, part of the language in the Ukraine resolution that I was proud to support had indicated that we were condemning Russia for not just an illegal invasion, but for theft of Ukrainian land. And if that was something that enjoyed unanimous support from the General Assembly, I voted for it, then we should also be against the theft and auctioning of Palestinian land by any government, whether it be the Israeli government or otherwise. So this isn't about the human rights record. This is about a specific policy. I think we could talk about the human rights record. That's a separate discussion. But this is about a specific policy that displaces Palestinians and puts other people in their homes and on their lands.
Delegate Taylor.
Thank you, Mr. Chair. Your bill focuses on nonprofits that are registered in Maryland, right? Only Maryland. And if we were to pass this law, would Maryland be the first state to, enact this kind of legislation?
Thank you for the question, Delegate. We'd be the first state, but we're not the first state that similar legislation or this bill has been introduced. Similar legislation has been introduced in the state of New York, where they also saw an uptick in nonprofits, essentially funding the building of settlements and then selling or auctioning off that land in whether it's in New York State. And so this bill is not new. It is something that other state that is being considered in other states, namely New York. And so my hope is that Maryland would lead on the East Coast, would lead the country in passing something like this that sends a clear message. And I want to be clear because I think the opponents this year, because apparently we have some new opponents this year, to include a lobbyist who we work with pretty often, there will be attempts by individuals to essentially label this bill as anti-Semitic. And I think it is part of an attempt to essentially mask to defend or to distract from the issue that is at hand here. And any opponent that comes after testifying in opposition to this bill, it is right for every single, or a good bit of this committee, to ask them whether they support what is being done right now in terms of displacing Palestinians, theft of their land, and auctioning of homes or lands here in the United States to an exclusive group of people who are not Palestinians. That is the question that you have to ask the opposition as well, because this isn't about anti-Semitism. This is about the policies of our government that is being pushed by a government and that is still in place right now. And I think any suggestion otherwise is really a distraction from the issue at hand.
Yes, thank you.
With his first, no. With his first question, as a member of the House of Delegates. Delegates to that.
Hey, here, here.
No pressure at all. Thank you, Mr. Chair. And I think that you, Delegate, you pretty much explained what I was pretty much overall wanted to ask, which is pretty much what is the overall purpose? What is the purpose of this particular bill? I know you addressed it a little bit, but I just want to make sure that I have a fully a good understanding of it.
Appreciate that, and welcome again, Delegate.
Thank you.
The bill, I mean, what issue we're trying to solve here is, as I mentioned repeatedly, and as I said last year, ending the practice, the frequency with which Palestinians are being displaced and their land is being sold. There is a two-state solution in place, and that two-state solution requires an adherence to international law. But if you have one side, one government that is essentially eroding international law, displacing individuals, the idea of a two-state solution has become less and less possible. And so if we say we care about rule of law, about legality and following international law, then this is the bill that we want to ensure that we're not just seriously considering, but passing.
Thank you.
Seeing no further questions for this panel, thank you very much. All right. Reem Assam, come on up. Khadija Abd Allah, Bushra Khatib, Mary Ella Jordak. At that, I believe it'll be all the people who signed up to testify in favor. We'll start from my right, please, or whichever way, that's fine.
Give me a second to unlock my phone, sorry.
Okay, well, why don't we start from my left then? We'll go that way, and go ahead, we'll start with you.
Good afternoon, Chair and members of the committee. My name is Reem Azam, and I'm here on behalf of Justice for All to urge the passage of this bill. Last year, the UN Office for the Coordination of Humanitarian Affairs recorded the highest number of attacks in nearly 2 decades, with approximately 4,250 Palestinians displaced, 1,760 structures destroyed, and 1,400 settler incidents across the West Bank and East Jerusalem. These numbers have since risen, with Palestinians now facing an average of 4 attacks daily. These are not just statistics. They represent lives, families, and communities being destroyed. Take Alice Kassiya, a Palestinian Christian whose family has farmed their ancestral land for generations. Israeli settlers backed by the military seized their land and detained Alice's brother. Alice and her family would return daily, erecting tents after their home was destroyed, but the attacks continued, destroying their tents around 17 times. Her elderly parents are now displaced and renting an apartment. There is not enough time to share all the tragic details of the story. I urge you to look it up. But Alice's story is not unique. Palestinians are routinely murdered, injured, and displaced in such attacks. It should be a crime to fund war crimes, yet our legal framework falls short of this moral benchmark. Passing this act is a crucial first step in limiting our complicity in ethnic cleansing and affirming that justice is not selective.
Thank you very much.
Human rights are not conditional. Thank you.
Thank you very much. If you're reading things and you would like to stop at the end of the minute and submit it in writing, that is perfectly fine. Go ahead.
Good afternoon, Chairman and members of the Judiciary Committee. I just also wanted to mention that the stats that my mom just read also apply to Palestinians in Maryland. Every Palestinian I know in Maryland has family who has either lost land, been imprisoned or held hostage, or been killed by the illegal Israeli occupation. Yet the state of Maryland allows nonprofits to funnel money and resources into these illegal settlements under the false pretense of charity. Maryland should enforce strict ethical standards for nonprofits and Palestine should be no exception. The UN, Amnesty International, and the ICJ have all condemned these settlements. Why would Maryland allow its nonprofit sector to fund them? As a student, I've noticed the suppression of Palestinian advocacy on campuses contrasts sharply with the unchecked funding of Israeli imperialist expansionism. Passing House Bill 1394 should not be controversial, nor is it an infringement of free speech. If Maryland prohibits nonprofits from funding human rights violations elsewhere, Palestine should not be an exception. Our state should not continue to subsidize apartheid and war crimes. Thank you.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Bushra Khatib, and I am here speaking in my own personal capacity as a Maryland resident and Howard County constituent. I am here today to express my strong support for House Bill 1394. I have worked for about 15 years for 3 different nonprofit organizations that were committed respectively to advancing research on physics, autism, and nicotine addiction. I chose to work for these organizations precisely because I believe in their missions. I could bring my best self to work every day knowing that they and I were firm believers in their missions and that their status as nonprofits meant something. The state of Maryland should take proactive steps to ensure that nonprofit organizations remain accountable and that they do not engage in practices that have been widely recognized as violations of human rights and international humanitarian law. Additionally, many people in Maryland, including people of my faith, think very hard about which charities and nonprofits to donate to. Thank you for your time. Just 1 minute. Okay.
One more sentence.
One more sentence? Okay, okay, thank you. As Marylanders decide where to work and where to give, House Bill 1394 is critical to ensure that Maryland leads by example in promoting human rights and accountability in our nonprofit sector. Thank you. Thank you.
Hi, my name is Mary Ella Jordak. I'm here today to show my strong support for HB 1394. In case y'all have not been paying attention over the last 17 months, Israel has been enacting a genocide in Palestine. On average, 1 child is murdered every 30 minutes. At least 50 nonprofit organizations across the U.S. have been directly involved in fundraising for Israeli settlements. Beyond illegal land expansion, that money has gone towards legal aid societies that do things like support the family of an Israeli who murdered 7 Palestinian laborers, or for a group of Israelis that attempted to detonate a bomb at a girls' school in East Jerusalem. While we cannot take retroactive action for the loss of life and land in Palestine, we can, at the very least, take steps towards ensuring that support for continued violence and illegal land theft does not happen on Maryland's watch or with the financial backing of its residents. Why should we be afraid of accountability and transparency for nonprofits? We are here today to say no more to the millions of dollars being funneled into illegal and immoral action. Aiding and abetting war crimes is not a value that we should share as Marylanders. Please uphold the Geneva Convention and international law by finding a favorable report for HB 1934.
Any questions for this panel? Seeing none, thank you all very much. I believe that's all of the people who are signed up in support of the legislation. Now, in opposition to the legislation, for 1 minute each, Bruce Bariano and Deborah Miller. Okay, we have one person who's in favor, who's virtual, and this is Killian McGinnis. So we'll do that, and then we'll go to Mr. Bariano. We have him. Killian McGinnis or Saqib Ali? Mr. Ali. Saqib Ali. Saqib Ali, last call.
Yes, I'm here.
All right, for 1 minute, please.
Sure. I just want to say me too for all the people who supported the bill. That's it.
All right, thank you very much. Not going to take questions for Mr. Ali, but thank you very much for your time. All right, now we're going to go to those people in opposition to the bill. Mr. Bariano, please, and I don't see Deborah Miller.
Good evening, Mr. Chairman and members of the House Judiciary Committee. For the record, Bruce Bariano. I'm here by myself, of Jewish faith. This bill, I've been here 53 years. I've never seen a more despicable piece of legislation introduced into the legislature. It's very, very sad, very, very disturbing. This bill is targeted against Jewish people here in the state of Maryland and in the state of Israel. The organizations that would be adversely impacted by the passage of this bill are the Associated, the Jewish Federation of Greater Washington, the Jewish Federation of Howard County, the Weinberg Foundation, the Blouseberg Group, and the Weinberg Charitable Fund. They're all nonprofits. The issues that are being presented by the proponents, all of which I am not fully versed about, are not really appropriate, in my view, to be taking up the time and attention of the Maryland legislature. You all know, and I know, you have plenty of work to do relating to the nuts and bolts of the state of Maryland. There is no other nation that is referenced in this bill other than the state of Israel, and there are no other people that are referenced in this bill, no other religion or any group other than Jewish people. It's a very sad day for me that this bill is here and being heard and getting the publicity it's getting. Thank you.
Delegate Cardin.
Thank you, Mr. Chair. Thank you, Mr. Bariano, for your testimony. I'm pulling up very quickly in the bill. So one of the things, are you familiar with the Associated? You mentioned the Weinberg Foundation. You familiar with the Associated Federation?
Yes, I am.
Okay, I apologize. Unauthorized support of Israeli settlements is defined as means aiding or abetting activity of the government of Israel or of a citizen of Israel. If the Associated had a nonprofit organization that was helping people with cerebral palsy in the state of Israel, and they are also they're alleged to have done something in this bill that would cause them to lose their nonprofit, would they then not be able to service those people in Israel because of that? Or would they lose their?
They would lose their ability to do that.
Okay. If the Associated had a program to help people with cerebral palsy in the occupied territories in Gaza, or for example, or in the West Bank or that area, they would not be able to service those people with cerebral palsy either. Is that correct?
That's correct.
Okay.
And in my visits to Israel, I've been there 3 times, I've seen, particularly in Jerusalem, a number of buildings that are hospitals or buildings of healthcare and stuff like that, with the names of people from from Maryland, from Baltimore, that are doing that good in the state of Israel. And if this bill passed, targeted solely at those people in those organizations, that would stop, and that would be an offense to be prosecuted by the Attorney General with a 10-year statute of limitations, being able to bring such an action and such accountability.
One more question, Mr. Chair. You've been working in Annapolis for many years, I would say for many decades.
53.
Okay, for more than 5 decades. Would you say that this legislation would help unify Maryland communities or help sow division in different communities in Maryland?
This bill is filled with hatred and bigotry and anti-Semitism, in my opinion. It would tear apart the state of Maryland. We have enough troubles and problems coming out of Washington. Unfortunately, in our own state, we need to come together because all people are equal and should be treated with respect and dignity.
Okay, so there are many of us who believe that we need to find a peaceful solution, perhaps I happen to believe in a 2-state solution in this region of the world. Would this type of legislation help create an environment where that is more possible? Or would
I do not think so, Delegate.
Okay, thank you.
Delegate Thomason.
I'm all right. He kind of asked what
Seeing no further questions for the
Thank you, Mr.
panel.
Chairman.
Thank you very much. That concludes the testimony on House Bill 1394. Go now to Delegate Arntz and Circuit Court judgeships in Queen Anne's County, which is slightly different. Delegate Arntz, please bring up your panel. Lance
Thank you, Mr.
Richardson,
Chairman.
Judge Knight, and Bruce Bariano again. I don't think the state's attorney's here, right?
Pardon me?
State's attorneys, cut.
Lance
Bay Bridge.
Richardson's not here.
The Bay Bridge stopped us.
Okay. Delegate Arntz, 3
Okay,
minutes.
We'll be brief. Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of the committee. For the record, I'm Delegate Steve Arntz. I'm here to present HB 975, the Queen Anne's County Circuit Court judgeships. The bill will alter the number of resident judges in Queen Anne's County Circuit Court by 1 additional judge. The additional judge will allow the court to process cases more effectively, reduce backlogs, and improve overall access to justice for the citizens of Queen Anne's County. I have letters of support from the Queen Anne's County Commissioners, the Sheriff's Office, the Clerk of Courts, the Office of the State's Attorney, along with the Queen Anne's County Bar Association. A brief note that the Clerk of Courts put in that she will note, the fiscal note mentions that she would need another clerk, but she does not need that, so that would be taken out of the bill, hopefully. Just a little history. This process started around about 20 years ago. In 2010, I was elected chairman of the Queen Anne's County Commissioners, and then the Clerk of Court, Scott McGlashan, along with our now Clerk of Courts, Catherine Hager, got together with our judge at that time, Judge Ross, and they were trying to address the needs for an additional judge back then. One of the problems we had is we sit in a very, very small courthouse back then, the oldest working courthouse in the state, and we talked about this, we had meetings for it, and after their urging, we got the commissioners to realize that to accommodate this new judge that they were seeking would need a larger courthouse. That process started in my second year as a commissioner, and in 2019, we were proud to open up our new courthouse that can satisfy, I think, about 4 new judges. Our judge, the current judge, has been supporting a very heavy caseload for far too long, and this change is needed to continue to and improve on the excellent work Judge Knight has demonstrated for our constituents. In the testimony, there's a letter from the Maryland Judiciary commenting on this bill and our request. Just to be brief, I'll summarize it. In that letter, they describe the process used today to review and assess the needs of an additional judge in Queen Anne's County. This model comes from the National Center of State Courts, which was last fully updated in 2017 and subsequently updates to in 2022 by the State Maryland Scope Workload Adjustment for District and Circuit Court Judicial Officers. That's a hard one. The model relies predominantly on new caseloads in the most recent fiscal years, unaffected by COVID-19. But as it reflects the judicial submission, the model identified a certified need for 4 additional judgeships. However, due to the variety of reasons, including space limitations, which we now have enough space to accommodate an additional judge, and fiscal considerations, they are not requesting any new judgeships. However, in the letter, the judiciary goes on to realize and recognize the limitations of the current model and are currently considering incorporating changes in legislation, court practices, and filing trends that have occurred since the last full update in 2017. Based on this, we're looking for a favorable report on HB 975. I'm happy to address any questions. Thank you. My name is Judge Lynn Knight. I'm the sitting judge in Queen Anne's County Circuit Court. We have 1 judge and 1 magistrate who handles nearly 1,500 new case filings every year. HB 975 adds 1 judge to our courthouse. We're currently going from 1 judge to 2, is something we've been asking for. I've asked the judiciary for the past 3 years since I've been on the bench, and we didn't have the space. We now have the space. We have 4 courtrooms with 4 judges' chambers, and there's me and the magistrate. We do bring senior judges in to sit, to hear cases, but what I want to point out is the Second Circuit, where I am, has 4 counties that have 1 judge, and so we have a smaller pool of senior judges to pull from. We had 2 counties in those 4 counties that had vacancies last year for over 8 months. And so all of our senior judges were sitting in those other courthouses. So it was really a hardship to have anyone assist the other courthouses. The model doesn't work for single judge jurisdictions. None of us, if you took the 5 of us who are single judge jurisdictions and put it in that model, none of us would ever get a new judge. And we're the largest in the area. We have the most filings, we have the largest population. We should be, and we are prepared and ready uniquely because the county has supported us. We have hired staff. All it would take is to bring a judge and their law clerk
and we would be ready to go. And so we're asking for a favorable report, and I'm happy to answer any questions.
Mr. Chairman, members of the committee, for the record, Bruce Bariano, I'm here on behalf of the Queen Anne's County Commissioner, my client, in very strong support of this legislation. The courthouse was built, specifically built to have an additional judge, as Her Honor indicated. It's ready to go. We just need the authorization by the legislature. One very important thing is that the comments, and whether it's opposition or not by the Administrative Office of the Courts, they acknowledge that they rely on a model, a national model, in determining factors. Well, that does not make any sense, particularly on the Eastern Shore in a one county, in a one court judge county. You've got to look at the particular characteristics and the realities. And I know they're looking at their model again, but I don't think they evaluated this properly and carefully. And I know from relationships and talking with people in Queen Anne's County that a second judge is very desperately needed. I know you moved the bill out for St. Mary's County. They had needs and everything, as well. But really hope that you will include Queen Anne's County. We're ready to go, and you'll have a speedy trial and quick justice, which we all want. Thank you very much.
Delegate Boucher.
Thank you, Chair. Thank you, Delegate, for bringing this bill forward. As a former county commissioner who brought on a judge, are the commissioners ready to take on the financial responsibility in light of the budget?
Absolutely.
Thank you.
Delegate, does the county pay the judge's salary?
It's paid
No,
by,
we don't. No, we do
The
not.
state of Maryland does.
Yeah.
The state of Maryland does, yes.
And did the judiciary support the St. Mary's County judge?
Yes.
Okay. Any further questions? Delegate Phillips, then the vice chair.
And I know the judiciary did come in and support the St. Mary's County judge, Mr. Chair, so thank you for that. But I also remember the judiciary saying that they needed to update their model. Have they talked to you about what implications an updated model may have on, and how, are you aware of what that might do?
Well, they haven't identified a new model. They haven't done an RFP to get a new program. They're talking about 2028 to get a new model, which means it would be 2029 or 2030 before they would be making any recommendations for any additional judges. So that's a long way in the future. They recognize, if you see their letter that they have filed in the case, they recognize there are shortcomings, and we've been arguing about those shortcomings for several years, which is why we decided to step forward on our own and say it's time, because St. Mary's doesn't have the infrastructure. They need to do something for the courthouse to accommodate their judge. We don't need to do that. And our county has fully staffed us, paid all of our staff salaries so that we can bring in a new judge. We're ready to go.
All right, thank you.
Vice Chair, never mind. Any other questions?
Do you want to say something?
Seeing.
Mr. Chairman, may I say one more thing?
Briefly, yes.
Yeah, I will be brief. I think one of the issues we have is we're looking for a judge because when these judges have to be traveling and we have to get another judge in, we're getting judges that are not familiar with our areas. And that's very difficult on how our area handles certain issues. And that's one of the things I think is more important about this, to try to get continuity within our district. And I appreciate the time. Thank you.
All right, that concludes the
Thank you very much.
testimony. Thank you very much from House Bill 975. We're going now to Delegate Hornberger. Delegate Hornberger's bill is House Bill 1112. It's him, Jonathan Goldberg. Okay. And yeah, it's just the two of them, and then we'll have those people in opposition. So Delegate Hornberger, please.
Thank you, Mr. Chair, and thank you to the joint committees for hearing HB 1112. For the record, Delegate Kevin Hornberger. This bill deals with PFAS. As many of you might be aware, this has generated a lot of publicity, unfortunately negative in the recent future, as it's been discovered that this causes adverse health effects. So why do we need this bill, and how did we end up at this juncture? I'm going to read you a small excerpt from the Cecil Whig that just issued this week. Currently, there is a class action lawsuit against W.L. Gore for contamination for both employees and people living in surrounding areas. Already 600 people have opted in to show that they have adverse health effects. One class representatives, and I'm reading from the article, who grew up near Fair Hill, moved there in 1989 and shared a story with the crowd at a town hall we had. After falling in love and getting married to her now husband, Danforth started noticing blood in her urine. She finally saw a doctor and found out she had kidney cancer. It was not until she learned about the Gore lawsuit that she realized the PFAS contamination caused her cancer. This is why we need this bill. So this body has taken actions to rid certain product classes in the past. However, my thought is that that is a weak tea approach. And the reason I say that is because most of those industries have already said we're going to stop using these products, and then the Maryland legislature comes along shortly thereafter and says, okay, we'll go ahead and ban them. We need to be on the offensive here and follow the same model that Maine and now Minnesota have enacted, which is to say we will ban all PFAS consumer products, and then we will work backwards for exemptions where there's no way to remove those contaminants from products. HVAC systems are one of those, and we have actually an amendment for those. So again, we're banning everything and then working backwards for certain product classes. So just a list here of what PFAS has already been determined to cause. And this is by a leading epidemiologist. Cancers of the kidney, testicles, liver, thyroid disorders, developmental delays, and lower vaccine responses in children, along with a host of others. The bill also establishes, and my colleague here is going to talk to that, a larger window of statute of limitations. And this approach is not novel. This is a workplace contamination. We mirrored the language that was used for asbestos. So nothing novel here in terms of the statute of limitations. It basically gives, because we're just now finding out the adverse effects, if someone has been impacted, 3 years of notice or 10 years from death or from a health determination. And I actually think we're entertaining an amendment that says whichever is the latter. So that gives them more time. With that, I'd love to take questions, and thank you for hearing this important bill.
Thank you, Delegate. Sir?
Thank you, Madam Vice Chair, members of the committee. My name is Jonathan Goldberg. I'm an attorney. I'm here on behalf of the Maryland Association for Justice regarding Bill HB 112. PFAS chemicals are known as forever chemicals. My firm is involved with handling a number of these cases of patients or clients that have been injured by these products. The ones that we are handling involve a product called AFFF, which is firefighting foam used by firefighters in the military and civilian, and some of the flame retardant materials that they wear. PFAS is in many products that we use and consume every day. It is estimated that 98% of Americans have detectable levels of PFAS in our bloodstream. The effects of PFAS exposure are still being discovered, but it is known, as the delegate said, to cause many different types of cancers and other types of injuries that are very serious and perhaps fatal. While PFAS has been around for many decades, its effects are still being learned and being studied today. And the evidence is still coming out scientifically as to the damages and disease caused by PFAS. HB 1112 makes sense in that in wrongful death cases where PFAS was a cause of death, it extends the statute of limitations to the earlier of 10 years from the date of death, or 3 years when the cause of death was discovered. The current wrongful death statute is limited to 3 years because it's a statutory creation. This would extend it to 10 years after the death. Along the lines of the continual gaining of knowledge of the dangers of PFAS, we would ask that the committee and the delegate to modify or amend the proposal to regarding what would be Section 5-113.1 of Courts and Judicial Proceedings. And that is to make it the latter of 10 years from the date of the exposure or 3 years from the date when the cause of injury was discovered. Many of the cases our people were exposed decades ago. So the 10-year statute or the 10-year savings would not apply in their cases. So we would ask that it be the latter of 3 years from discovery or 10 years from exposure. Thank you.
Thank you. I have a quick question, and then I'm going to go to Delegate Taylor. And I think Mr. Goldberg, or either could answer this question, but just one, please. So is it easy to
determine death, the causation of death as exposure to PFAS chemicals? Is that an easy determination, and are there tests that are out that make this determination?
Is it easy? I don't think it's ever easy.
Easy,
Delegate.
is it relatively? I'll say relative, in the sense that is there a direct causation that can be made from the death and the exposure to PFAS? That's what I'm getting at.
Sure, there are certain cancers that are scientifically proven to have, that PFAS can cause.
Okay.
And so if that is the cause of death, then you can work backwards and see, was the individual exposed to PFAS, in what setting, and then it becomes, did that play a role in the person's death or not?
Okay, that answers my question. Thank you.
Yep.
Delegate Taylor.
Thank you, Madam Chair. Can you give us an idea of the scope of this issue? Number of people that might be affected?
Yes, so in Cecil County, this is probably one of the worst ecological disasters in our history. Whereas it contaminated our groundwater, our surface, our air. Because these facilities were in rural areas, all the effluent that was dispersed from the buildings did not go into a sewage treatment facility. It went into open ponds. So we now have a plume around the 13 facilities, whereas everyone living in those adjacent facilities, and then again, this is pristine, very rural areas, now has extremely high levels of contamination in their groundwater that they've been consuming because they're also on wells, and unknowingly have been ingesting these chemicals for over 50 years.
What are the facilities you're referring to?
These facilities mostly made clothing, membranes, anything where there was a need for a waterproof or a non-stick resistant, such as things like Teflon would be another example. But here's the scary part. These products, and that's why we've been very broad here with this scope, these are used in menstrual products. These are used in containers. The only way to know what they're really in is to enact this ban, because we have a knowingly introduced clause in here, and then have the manufacturers of said products come to us and say, we have that in our product, there's a disclosure, or there's a waiver process that we need to implement. Otherwise, we're just going to continuously, unknowingly poison ourselves with these products. So again, what triggered this was same thing in Maine and Minnesota. They had large manufacturing facilities, all the adjacent residents, and then all the employees have come down with these specific types of cancer.
Thank you.
Yep.
We are hearing this bill with some members from the Health and Government Operations Committee and from Health and Government Operations, Delegate Hill.
Thank you, Madam Chair, and thank you, Delegate, for this bill. Those of us from Health and Government Operations are actually dealing with a PFAS elimination contamination ban bill right now.
Yeah, for pesticides.
But for pesticides and herbicides.
Yes.
And so the question is, when you have PFAS that was in manufacturing, which you're describing, and you have it in pesticides and herbicides that we're being told, we have to be slower on phasing out, because if we phase them out too quickly, it will be disastrous, particularly to rural areas.
Okay.
How does this bill work where a person, you've got an absolute ban, and then you've also got liability here without being able to prove what the source of the contamination was? So with firefighters, there's a reasonable presumption because of the materials they deal with, right? And I suppose if someone was manufacturing cosmetics that we've already banned, we could make a proof there, but this broader ban, I'm really having a hard time understanding.
I can answer that question, and I've spoke to one of your colleagues about this. As written, it's our belief that this bill does not apply to pesticides or herbicides, and that is because I, as the consumer, cannot go and purchase those items. So I can't go, the people that are applying these pesticides and things that you're dealing with in that committee, that is a business-to-business transaction. These are direct consumer goods. So I, as the consumer, can't currently go and purchase the items you just described. And I support that bill, by the way, just full disclosure. But I think as written, this doesn't apply. And because Maine and Minnesota have already tackled this issue, they've gone so far as to say secondary sales of items that contain PFAS, for example, there is no liability. So if I inadvertently am selling my frying pan or my clothing that has a PFAS contaminant in it, secondhand wouldn't apply to them. So this is just consumer-friendly products that you would go and purchase at any level store.
Okay, and if I may follow up? Okay, so then getting back to the liability part, which is the first part of the bill, if we're still being exposed to approved PFAS, pesticides, herbicides that stay in the fluid, get into the groundwater, get on our food, cannot be washed off, whatever, how does that affect this liability component when you're trying to say, again, not in an extreme condition where we know that the work environment had high exposure or that there was a plant nearby, but this general thing that you should be able to say, you must have been the source of my PFAS?
Yeah, I'll say two things to that, and my colleague here can elaborate. The banning of PFAS is not a question of if, it is a question of when. In the near future, we will see a full prohibition on these products because they are just so a detriment to our health, okay? Number one. Number two, this specifically bill, the statute of limitations, is workplace hazard, so you would have to be an employee. And I'll let my colleague here elaborate on that.
Sure, thank you, Delegate Hill. As far as, I guess you're asking proof of exposure causing injury or death?
Right.
It would go through the litigation process, and right now there are many lawsuits around the country, including there's an MDL, multi-district litigation, pending in federal court in South Carolina with thousands of cases, and that is one of the issues. But it goes through the litigation process, and it's a burden of the plaintiff to prove the causation and to prove that the exposures would cause the injury or the death.
Okay, so then let me ask this, and this will be my final question, I'm almost sure.
Yep.
So why can't it go through the litigation process now? If the EPA has said these are forever chemicals, we've got scientific evidence that they cause significant or can cause cancers, why now can't I say, hey, I've had this exposure, I came down with this particular type of cancer, I think it was the PFAS, my wells were contaminated because there was a factory nearby. Why can't we go through that process now?
Well, I think you can go through the process. The issue is the statute of limitations that would apply to that. So if it's a death, right now, it's in Maryland, it's 3 years from the date of the death, even if you don't know what the cause of the death was.
So it's that narrow part of the bill, the rest of the bill is not as important to you as the statute of limitations?
I'm focusing solely on the statute of limitations part of the bill.
Very good, thank you.
Yeah, and I would add to that the Attorney General is also suing Gore for the contamination of the environment. So there's multi-level litigation going on here, not only from the state, but from class action lawsuits to address the negative impacts that have had on the community.
Thank you.
Thank you, Delegate. Delegate Tomlinson?
Thank you, Madam Chair. I might have missed this, but so currently, there is a legal limit on how much can be in a product? Or no, there's not at all? It's just
financial limits.
I'm not aware of any, no.
Okay.
Just time limits.
Gotcha.
Yep.
Wait, what did you say, Delegate Horn? You said?
There's just time limits, statute
limits,
limitations on the window of time.
Right, and if I may, Delegate, also, certainly the limitations that apply to tort cases in Maryland regarding the damages, if that's what you're talking about for finances, yes, that would apply.
Yeah, we're not seeking to change that.
Delegate Sample Hughes?
Thank you, Madam Chair, and thank you, Delegate Hornberger, for the bill. I know we have some local issues, but that's more on an industrial level. The gentleman, with regards to the 3 years from the death of being an option to investigate further, are there specific things that would be in the death certificate that would rise to the occasion of saying that this is potentially the reason?
Sure. If the cause of death is a type of cancer or disease that is known to be caused by PFAS exposure, then that would lead to further investigation to try to see if the decedent had been exposed to PFAS and whether there's a connection between the PFAS exposure and the death. The issue is that 3 years, although it may seem like a long time, really isn't when you're dealing with something like this where you have it's not like you have a heart attack and you know that it's the cause. You have cancer, what caused the cancer? And so it takes time to investigate that. secondarily to that point is that the science is still evolving as to what damages PFAS can cause.
Right.
And so what may be known today may not, or what may be known 5 years from now, obviously isn't known today, and 5 years from now is beyond the 3-year statute of limitations. So this permits the family in Maryland of somebody who has died, and it's learned after more than 3 years, but up to 10, that it's because, or likely due to PFAS exposure, it gives them a chance to seek redress for their loved one's death.
Okay.
Yeah, and I would add to that, there's one departure from the asbestos litigation. It's been found that this also causes infant mortality as well as birth defects. So that's where this is a unique departure from asbestos, whereas I don't know if there's any proven being able to pass on to children impacts. So this adds in offspring of workplace hazard, and that's what's really unique about this bill is it covers the young people. And then I would also add that because this exposure builds up in the body, young people are even more susceptible to exposure because they're ingesting it over longer periods of time, and the body doesn't know how to expel this chemical. That's why you get these adverse health effects. Thank you.
And thank you, Delegate, for raising that point, because when we just recently had this issue, or made aware of it, I think it was the fall of last year, the area of the industry is near elementary school.
Yep.
And I know the water system is different, et cetera, but again, that was one of my concerns. So thank you for the explanation.
No problem.
Thank you. All righty. So that concludes this panel for House Bill 1112. We're going to go now to our panel that has signed up unfavorable. David Cadu, Stephen Burns, John Kane, Riaz Zaman, Candace Luan, I'm sorry, I know I mispronounced your name. Josh Young. Oh, just take a seat anywhere, it's good. Because if you have a particular order you want to go, you can just let me know, but just take a seat.
Yeah. This is Josh. He's on the panel as well, but we just ran out of seats.
Yep. We're gonna have to. Okay, so we got it settled.
Thank you very much.
Because we're gonna have another panel after this.
Oh, okay. All right.
Okay, all righty.
Thank you so much, Mr. Chairman, members of the committee. Josh Young, Senior Director of State Government Affairs with the American Chemistry Council. We submitted written opposition to this bill. It had over 50 different trades and organizations that are opposed to this bill. Not going to go into those details, but just want to hit a few highlights in our short time. First, let me be clear. This is the most far-reaching legislation in the United States. This bill would ban all consumer products that contain any PFAS chemicals. It would have a negative consequence on nearly every sector of the economy, including aerospace, automotive, alternative energy, healthcare, building and construction, electronics, pharmaceuticals, and agriculture. Further, it would then hold liable any group or even any person that manufactures, sells, or distributes a product that contains even a trace element of the chemical. Given the lack of a definition of PFAS in this bill or exposure thresholds, liability could then be extended to almost any consumer product in any Maryland business, such as airports, fire departments, local retailers, rental properties, home builders, hospitals, grocery stores, automobile manufacturers, and dealers. The list goes on and on. This would have a chilling effect on the state's business climate and create significant potential legal costs on various entities, including even the state and local jurisdictions. Lastly, and let me be clear, Maryland has already taken aggressive action and continues to take aggressive action on specific PFAS chemistries and specific consumer product ban bills. In the past 3 legislative sessions, Maryland has passed bills banning PFAS in firefighting foam, carpets, rugs, food packaging, disposable medical gloves, and playground equipment. Unfortunately, this is just a non-workable bill. It is too broad. It affects every considerable consumer product that you can think of. We want to work with you on bills moving forward. We certainly want the safe handling of the chemistry and the safe handling of the consumer product, but this bill goes way, way too far. Thank you.
next, and if you just give me your name, thanks.
Yes. Good afternoon, Vice Chair and members of the committee. My name is Riaz Zaman. I'm with the American Coatings Association. Our members manufacture paints, coatings, sealants, and adhesives, and the chemicals that go into formulation. Today, I'd like to emphasize that PFAS is a very broad categorization of chemicals. It encompasses over 1,000 different types of chemistries. There are fluorinated chemistries that are non-toxic and not bioavailable that are utilized by industry in a controlled manner to minimize the potential for adverse environmental and health effects. Some examples include coatings used in critical infrastructure projects, such as water infrastructure. Another example are high-performance coatings with fluoropolymers that significantly prolong the life of bridges and buildings. And yet another example are coatings that slow the spread of industrial fires applied to industrial buildings. Lightly fluorinated solvents are also used to manufacture low VOC paints. VOCs, of course, are volatile organic compounds. These are associated with the formation of smog in urban environments, and the paint industry has been a leader in minimizing emissions of VOCs from its products. The fluorinated solvents that make this possible are excluded from EPA's definition of PFAS, but they would be banned under this bill. Considering beneficial uses and that not all PFAS are persistent, bioaccumulative, and/or toxic, and usually scientists require at least 2 of those characteristics to classify a chemical as a chemical of concern. HB 1112 is overly broad. You have to keep in mind contamination is typically caused by legacy forms of PFAS that are no longer manufactured and that were mishandled at that time. These forms of PFAS are no longer in products. They're not used in the US. The general ban would affect a variety of products that are not harmful to human health or the environment, many having safety and/or environmental benefits. Thank you.
Thank you, Madam Chair and committee members. Stephen Burns, representing Cookware Sustainability Alliance. I want to make my suggestion, my point at the start in case I run out of time. Rather than the sponsors looking at exemptions for product classes, they might consider looking for exemptions at safe chemicals. There are actually 14,000 different chemicals that are under the PFAS group. The one that I want to talk about, as you mentioned, is fluoropolymers. Fluoropolymers are up to 1,000 times longer than PFOA or PFOS. They are non-toxic. They are inert. They cannot attach themselves to organic matter, to the human body, to the water system. They're used in nonstick cookware, of course, because of their properties. But they're very different, and every point that I just made has been published in independent refereed scientific journals for a number of years, for decades, in fact. Fluoropolymers are not just coating nonstick cookware. They coat every single pacemaker, stent, and catheter that the medical profession has used for decades. And so some of the proponents around the country, as a matter of fact, 11 states are looking at banning various products. They'll often give an exemption to medical devices, and we all don't want to outlaw pacemakers for obvious reasons. But if fluoropolymers, which is one of the PFAS chemicals, is allowed to be inserted into the human body, considered safe for decades with no signs of toxicity, then it's difficult for us in our industry to understand why frying an egg all of a sudden becomes a dangerous activity. So as I said at the outset, I'd really encourage the committee to look at science and look at each one of these chemistries different and not look at just product by product. Thank you very much for your time.
Yeah, my name is Dave Cadu in Frederick, Maryland, with the Communications, Cable, and Connectivity Association. And just as perspective, all of the electronics you use, your cellular devices, your computers, the cameras in this room, the TV monitors, everything that connects society in a smart building uses these materials. And it's important from a fire safety standpoint that the flame spread and smoke generation is minimized, which these materials are used for. But more importantly, this bill is really calling PFAS like a one singular product. It is not. It is 4,000 different products, some of which are harmful, and mostly are intermediates in manufacturing. Responsible manufacturing is required. Delegate Hornberger referred to some issues in his county. Well, that's about environmental compliance and working to have good, responsible manufacturing. But these materials are essential. I mean, society stops without these materials, the fluoropolymers in particular. Airplanes won't fly, cars will not drive, your cellular phones will not work, and so many others. It's particularly in healthcare, in the operating room, and medical devices, because of the materials. Fluid resistance and temperature resistance and many other properties, the engineering balance, are essential. And so this bill, unfortunately, calls PFAS, covers everything, and that is not appropriate. And referring to Maine and Minnesota and California and the European Union, each one of those states have either now gone way back on their original bills because of the lack of data to say what PFASs are in fact harmful. So I encourage you to not support this bill.
Yep, if you could. Can you bring the mic even closer to you, please? Thank you.
My name is Candice Leloirne. I'm representing the Cookware and Bakeware Alliance, an association of 60 member companies that manufacture and sell cookware responsibly across the states and internationally, meeting the highest safety standards. Many of our member companies use PTFE coatings, which play a critical role in delivering the non-stick performance that consumers expect and at an affordable price. No state has ever enacted such a broad PFAS ban on all consumer products. It's very important to note, too, that this PFAS definition is a very broad family definition covering thousands of substances with different risk profiles. While some PFAS raise concern, and we call them the PFAS of concern, some other PFAS, like fluoropolymers and the PTFE, are safe and recognized as safe by the FDA as completely approved for non-stick coatings. So it was reaffirmed just February last year by the FDA that non-stick coatings are approved for food contacts, and related materials such as gaskets made of fluoropolymers are also approved. And other trusted bodies like the ETRC, for example, has noted that PTFE pose no environmental, ecological, or health risks once it's in a finished product. So given this broad scientific consensus, we respectfully highlight the need to distinguish between PFAS of concern and PTFE. Thank you.
Thank you. I think my question, if I have the names right, it might be for... You didn't testify?
Well, I switched out. I can go next, I can go now. I call my name out.
But we don't do that. You can't do that because we need to ask the questions of the person who was actually testifying.
Yeah.
So do you mind just switching back?
Sorry, I was called. I wasn't sure.
Don't worry. I've got another panel. I'll call you on the next one. I promise. Okay, so thank you. So my question actually is for Mr. Burns. Who's Mr. Burns? Yes, that's what I thought. Okay, so I have two questions. Did you see what we're defining as PFAS chemicals in the definition in the bill?
Did I see that?
Yes.
Yes,
And you still think that that is too broad?
I do.
Why?
Because when you define it as broadly as it currently is written, and it's written that way in most states, it does include the chemistries that three of us are talking about, fluoropolymers, because of the single carbon backbone.
Because it says at least one fully?
At least one.
Is that why? Okay.
That's right.
Okay, so how does one die by exposure to PFAS chemicals? Because you all mentioned that it's basically everywhere, and I'm only asking Mr. Burns this question only in the interest of time. I'm sure each one of you on the panel could answer this. But you're saying that it's everywhere, so that means that we obviously can sustain an amount, that is sustainable, but how much is needed for one to die from it or have cancer?
Not being a medical doctor, I'll give you what I've read over several years period, which is primarily through water ingestion and secondarily through skin or contact, right? And so that's why my testimony was about a type of PFAS chemical that is inert, doesn't bioaccumulate, cannot get into water.
But I guess what I'm getting at is, does it then become irrelevant that it's used in the TV and everything else?
I would argue yes, but the example of firefighting foam, obviously very different. It's sprayed in the air, it gets into the ground, it gets into the groundwater. That's a very different, and that's a dangerous PFAS.
Right. Okay, I got you. Thank you.
You're welcome.
Delegate Grammer.
Thank you, Madam Chair. How many PFAS compounds are there?
I've seen reports that there are over 4,000 that come in the classification of PFAS. And again, you've got to make sure you understand that it can come in gas form, liquid form, or solid form. And that's very different in terms of exposure and the risk of certain PFAS materials. Fluorinated chemistry is what we're talking about. And fluorine has been used for decades in a lot of medical and critical applications. And that's why, again, I wanted to be very clear that this bill would basically bring society to a halt in Maryland, because almost every ingredient, every device and application we use today use these harmless materials proven by the EPA, by different medical organizations, and a lot of study. So just be sure we understand that there are specific PFAS materials in whether it be a foam state or whether it be a gaseous or liquid state, most of which are intermediates. The stuff that's in commerce today, the stuff that we have in all of our devices and products at home are inert. What's in airplanes and cars and computers and microchips and everything else, your stents and your pacemakers and everything, completely harmless and inert, and that's why they're used, okay? So just, again, you really have to narrow down the specific problems, and that's the problem with some of these litigations that was referred to in the previous testimony about cause of death. Because again, where was the exposure? What was the type of exposure? What was the concentration of exposure? There's so many factors that go into it. And what were the ingredients? And that's where it becomes complicated. So
that's a perfect segue to my next question. What if we took out the prohibition in the bill and left in the civil liability? And I asked that question for this reason. If we took out the prohibition, people in this committee wouldn't have to worry about which of the 4,000 compounds were at question, or if it's in our TV or frying pan or stent, or how it's exposed. We would just say, as we kind of done with other products, we would say that if somewhere someone did prove that there was a particular compound that was the cause of someone's death or cancer or problems with their offspring, we're not really in the business of figuring that out here, but you folks most certainly have an interest in making sure those products are not available. And if it is found, isn't there a matter of justice in saying, there probably should be a liability, and even though we're not going to get into the business of picking out compounds and pointing them out, that if it is proven, and this is how these cases tend to arise, someone finds that there is a compound that's deleterious to health, and then that comes up and people litigate, isn't there, wouldn't it be prudent to have some kind of mechanism for liability there?
If I may, I've been part of this conversation in other states and in the European Union as well. The issue really is public perception. If the state of Maryland comes out with this PFAS bill the way it stands, or even without the prohibition, you raise a lot of concerns to the general public that just aren't warranted or justified, and there's no scientific basis for doing so. And so That's why, yes, there's a lot of concerns, a lot of materials, and we have to go through a lot of studies to make sure that they are safe. And that's what's been happening for many years. A lot of the original technologies in the 30s and 40s, and you can apply this to a lot of different materials, where the manufacturing process is completely changed based on known information. And that's where I think, the public perception and the concerns, you're addressing it, right? You're thinking about it, which is good. But what ends up happening is you'll create a meaningless bill and just create a lot of euphoria when in fact you've got thousands and thousands of exemptions because of necessity. There's no alternative materials that have this balance of properties. And that's where the concern is now. So, and it's like PVC. Is your shower curtain hazardous, right? Because a lot of people say, oh, PVC is toxic and all that stuff. Well, get down to the realities of that finished product, not necessarily the intermediates in the manufacturing, responsible manufacturing. Let's talk about the finished consumer product. And that's where, legislatures like this in Maryland, who's very responsible. I love living in Maryland because we think about this stuff. But in reality, you're just going to throw a lot of scare out there, and people are going to say, wow, I can't use my phones. It's going to cause me cancer.
I get that, but what you're saying is there's no concern at all for PFAS chemicals to be.
I've never said that. I think there's certain PFASs in certain applications that are, should be concerned and regulated, and that's what we're all here for, is to regulate the right ones, not the broad class.
Should there be liability for those cases?
I can't speak to that.
Thank you.
Would you provide us a list of those?
Of the
No,
list of the
ones that this gentleman was just mentioning. You said there are some, and you knew of some that are dangerous. Would you mind providing us a list of those?
Yeah.
Thank you so much.
Be happy to, Madam Chair.
Okay. That was okay. Delegate Cardin.
Just, so the fluoropolymers that I think the two gentlemen in the middle were talking about, I'm not a scientist. When somebody tells me that there's chemicals that will remain in my body for the entire duration of my life and there's no way for me to expel them, that makes me nervous and excites me as somebody who wants to try to live a long, happy life. If I had a glass, and if we had that, I think you described it, it was very well described, like a coating on a bridge was one of the descriptions of how you use these fluoropolymers. If I had a cup full of that dust that came off of that after years of scraping it or whatever, and inhaled that, are you saying to me that that would not be able to be captured in my body and it would somehow be expelled out?
Yeah. I think you're the fluoropolymer association.
Fluoropolymers, because of their length and weight, pass through the human body. They do not bioaccumulate. They've never been shown to. And so the label of forever chemical, which is hung over this conversation, this debate, rightfully so, in PFOA and PFAS, to give the bad chemicals, does not apply to fluoropolymers. They cannot enter membrane. They cannot bind themselves to organic matter. So if you took a cup and drank it,
it would flow through.
It would pass through, just to be clear.
So going back to what the Vice Chair just asked, so we can identify, and you think you can provide to us maybe a list of the folks, of the 1,300 chemicals that will pass right through, and the 100 chemicals maybe that we should be aware of. Maybe we can differentiate that way? Is that possible to do?
I'd like to work with.
Yeah, I'm not sure it's that simple, but we certainly would work with the committee on narrowing the focus and having that scientific discussion.
And the last quick question, so you mentioned that Maine kind of went forward and then kind of bounced back a little bit, the gentleman there. If we followed the direction of, for example, Maine, you guys would not oppose the legislation, is that?
I would also not state that. Maine is having tremendous problems implementing this, and that's why they're seeking the exemptions. I wouldn't call that a model to which a state would want to pass something.
May I offer two data points, if I may? 6 states have actually passed it. 2 of them who signed into law broad product bans last year were the state of Connecticut and the state of Rhode Island. The governors in both cases, upon signing, one in signing a message, the other privately afterwards, said, I want some groups to come back because I'm learning more as the process goes on. And there are now bills moving through the legislature in those two states that I just named, which are seeking to clarify the good and the bad.
Thank you.
And I'll also add that Janet Mills, the governor of Maine, has recently signed LD 1537 that substantially reforms the bill because of this discussion. It was, the original bill was passed through without a whole lot of consideration, with all due respect. And now they're having to completely reform it and have literally thousands of requests for exemptions. So the state of Maryland would have to experience that as well, unfortunately.
Thank you. Madam Chair.
Thank you, but I just want to clarify, my request was not for the 1,300, my request was for the.
The bad ones.
Yeah.
Yeah,
Okay, just to be clear. Delegate Embry.
Thank you. I wonder if you could talk about the state of Washington. My understanding is they delegated some of this work to their regulatory agency, and I just wanted to understand their approach and what you think of that.
I don't have all the details.
Yeah, we can provide that to you. Again, each state is looking at it differently, taking it perhaps out of the legislative approach into more of the regulatory approach. But I think either way you do it is, having it be based in sound science and having that as the backbone is really the key, whether you're crafting legislation or reviewing it through the regulatory process. And I know here in Maryland, I think there's a PFAS, action committee and workforce that reviews a lot of this stuff and has obviously in the state has passed certain product bans with PFAS. So.
Thank you. Okay, so that concludes this panel. We have another panel, unfavorable, John Keene, Michael Ratchford, Hannah Allen.
Can we lead us off?
Yeah, just start.
And your name, sir?
John Keene.
John Keene, I have been waiting for your testimony. I know it's going to be compelling.
Yes.
Go for it.
I heard my name last time. That's why I came up. I apologize. So.
All righty.
Good afternoon, Vice Chair, members of the committee. My name is John Keene, the Association of Home Appliance Manufacturers, also known as AHAM. In regards to House Bill 1112, asking for an unfavorable report due to the serious unintended consequences of this proposal. AHAM represents major portable and floor care appliances across the United States and Canada. Under the proposed bill, consumer products that contain PFAS would be banned next year. With this, it would include products many Marylanders as myself use, refrigerators, stoves, microwaves. With this extremely broad ban, it would include semiconductors, wirings, and important to us, refrigerants, which have been approved by EPA to kind of combat climate change. With this tight 2026 deadline, manufacturers will need time to find alternatives, test them, then recertify them, then redistribute by next year, which should be very, very challenging. Many of our products are bound to safety standards, and this proposed bill would require certification to meet those new standards if this would move forward. And pushing potential substitutes could also jeopardize the health and safety of Maryland residents who rely on our products every day for their daily living needs. Ultimately, we strongly encourage you to consider the potential implications before moving forward onto the proposal and encourage an unfavorable report. Thank you.
Madam Chairman, members of the committee, thank you for the opportunity to appear before you this evening. I'm Michael Ratchford. I'm a government relations associate with W.L. Gore and Associates. Gore is a privately held company and a Maryland manufacturer since 1971. Our Maryland facilities are located in Cecil County, where we're the largest private sector employer, with 2,900 associates working in 13 facilities. Our core material is PTFE, a fluoropolymer that was referenced in the first panel. It's a type of PFAS with distinctive characteristics, distinctive from other PFAS that may be more problematic. I'm here in opposition to House Bill 1112, specifically the language that would bar the manufacturing, sale, offer for sale, or distribution of a consumer product that contains PFAS chemicals. That language pretty much describes our entire operations in Cecil County and the state of Maryland. If enacted as written, it would render our operations unviable as of July 1, 2026. Example of the products we make in Cecil County include Gore-Tex membrane for use by the U.S. military and first responders, implantable medical devices, clean energy and other environmental products, Elixir guitar strings, spaceflight cables that are used in satellites across the universe, automotive vents, and a couple of years ago we had a Stay Pure bag that was used to make RNA vaccines and to store those. Because of the properties of PFAS, it could hold up. So for all these reasons, we respectfully request an unfavorable report on House Bill 1112.
Good evening, Madam Chair, members of the committee. For the record, Hannah Allen here today on behalf of the Maryland Chamber of Commerce in respectful opposition to House Bill 1112. As you've heard from previous panelists, the bill is doing two main things. It is broadly banning the manufacturing and the sale of all consumer products in the state that contain PFAS chemicals, with the quickest implementation date that has been introduced in the country thus far of 9 months from when the bill goes into effect. And it also expands the civil liability significantly for businesses by creating a separate cause of action for PFAS exposure. The expanded liability here means that companies and businesses that have fully complied with existing environmental and safety regulations could face lawsuits years and even decades down the road. I'll say businesses certainly recognize the importance of addressing environmental and health impacts from PFAS, but we cannot treat all PFAS chemicals, which include thousands of different chemicals that you've heard talked about already, as equally harmful, which is what this bill is doing. There are thousands, again, of different chemicals that apply within the PFAS family with vastly different properties and risks associated with them. So as introduced, we are concerned that the bill is broadly threatening supply chains, manufacturing, and small businesses without viable alternatives in place. As the fiscal note outlines, this would have a meaningful impact on small businesses. And importantly, it also states that the number of regulated consumer products that this applies to is assumed to be substantial, but they were not able to clarify exactly what those products were. So given the broad nature of the bill, there's just a lot of confusion and concern over how broadly this could apply. The chips in our phones are covered in PFAS to make sure that they are non-corrosive and non-flammable. You've heard the medical device argument, vehicle manufacturing, it's everywhere. So I'll stop there, happy to take questions, thanks.
Any questions? Seeing none, we thank you very much, and I believe that completes the testimony on House Bill 1112, and we thank our friends from the Health and Government Operations Committee for coming by and seeing us here today. They are leaving, more like running out of the room. And now we'll go to House Bill, is Delegate Lopez out there? Are you here for Delegate Lopez, or? Yes, okay, Delegate Lopez's office will be coming forward. House Bill 934. Layla Gretton, Woody Kessel, and then Paul Neistat and Ramya Swamy. All right, we'll go with these three and we'll go from there. Please begin for 3 minutes.
Thank you to the Chair, Vice Chair, and Judiciary Committee members. For the record, I am Emily Charlap, Delegate Lopez's Chief of Staff. The delegate apologizes for not being able to present tonight. She is currently teaching her class Communications for Social Change to graduate students at George Washington University. Today I present on her behalf HB 934, which expands the authority of the Center for Firearm Violence Prevention and Intervention housed in the Maryland Department of Health. This new authority includes the ability to create resources, tools, tools, and educational materials. In addition, this bill empowers the center to coordinate with state and local agencies, as well as third-party organizations in the design and dissemination of these documents. Maryland has been a leader in this space by passing safety-focused, community-centered firearm legislations, but we need to ensure that we are educating our residents about resources and legal changes as we continue to do so. Last session, the Maryland General Assembly passed HB 583, presented by the administration, which created the Center for Firearm Violence Prevention and Intervention with the Maryland Department of Health. The mission of this office is to view gun violence from a public health lens and to implement programs to reduce firearm violence and the misuse of firearms in the state. We know that gun violence prevention requires a whole government approach, and this center brokers collaboration between the Governor's Office of Crime Prevention, the Maryland State Police, and other Maryland stakeholders, including community partners. In an average year, 805 people die by guns in Maryland, and another 1,700 are wounded per statistics provided by the Center for Disease Control and Prevention and Everytown reports. Gun violence costs Maryland $10.5 billion each year, of which $384 million is paid by taxpayers. HB 934 increases the authority of the center by outlining and expanding previous language regarding their main mandate to conduct public awareness campaigns, as well as including the authority to work with partners specifically on those programs. The addition includes specific campaign topics, as well as any other topics the center determines appropriate and necessary to promote firearm safety in the state. The specific topics are the secure storage of firearms, extreme risk protection orders, and suicide prevention, including the 988 Suicide and Crisis Lifeline. This legislation does not mandate any timelines or additional requirements and simply enables the center to expand its reach within communities and across the state. HB 934 reinforces the benefit of this Center for Firearms Violence Prevention and Intervention by expanding its authority to produce educational resources on vital topics. The inclusion of state and government partners, as well as non-governmental community partners, will ensure the efficacy of these campaigns, both in creation and dissemination. I would also like to mention that this is a priority bill of Brady United, and although I believe we lost our representative due to scheduling change, I will send their testimony to the committee members after the hearing. Thank you, and I ask for a favorable report on HB 934.
Thank you. Good evening, Chair Clippinger, Vice Chair Bartlett, and distinguished members of the Maryland House Judiciary Committee. Thank you for the opportunity to speak in support of HB 934. Again, my name is Layla Greeton, and I'm a high school student at Archbishop Spalding High School. I'm the founder of Team Enough Baltimore, a youth-led initiative dedicated to ending gun violence under the Brady campaign. My generation is experiencing a public health epidemic across the country and the state. On average, 67 children and teens die by guns every year in Maryland. 17% of these deaths are suicides and 82% are homicides. We can no longer watch as my peers across the state lose their lives to something so incredibly preventable. HB 934 is a critical tool that provides clarity for the powers of the Maryland Center for Firearm Violence Prevention and Intervention. It creates an explicit pathway for the center to create resources, tools, and educational materials related to the secure storage of firearms, extreme risk protection orders, and suicide prevention. It also enables the center to work with local agencies to develop approaches tailored to the unique needs of each area. The powers allocated to the center through this bill will bolster Maryland's ability to prevent firearm violence, rather than reacting after someone has already been harmed. The work that the center does will make an incredibly positive impact and save countless lives. Without the institution of such organizations in our community, we would not be able to combat violence, especially gun violence, on the same scale. Thank you to Delegate Lopez for her sponsorship of this bill and to the committee members for your time and consideration. I strongly urge a favorable report for House Bill 934. Thank you.
Thank you, Chair Clippinger and Vice Chair Bartlett, and the distinguished members of this committee, and for staying to hear the information about this important piece of legislation. My name is Woody Kessel. I'm a professor of pediatrics and public health at the University of Maryland. I, along with my colleague Joe Richardson, co-direct a new effort initiated by President Pines called Progress, Preventing Gun Violence Through Research, Empowerment, Strategies, and Solutions. The ability to draw on all the assets of the University of Maryland to prevent this activity is unique in this country at this time. We are testifying here today in support of Delegate Leslie Lopez's House Bill 934. As you know, gun violence is a tragic epidemic happening in our homes, on our streets, in our schools, in our churches, synagogues, mosques, grocery stores, hospitals, campuses, malls, arenas, bowling alleys, everywhere. Well, I could share with you, and as my colleagues have done, there are statistics for the deaths. One death is in fact too many, but the deaths only confound the understanding. There's 3, 4, 5 times the number of consequences of injuries from gun violences that are affecting all of us, particularly here in Maryland. And as a pediatrician, I sadly note that gun violence is now the leading cause of death for children. I've been practicing pediatrics for 50 years. It's untenable, unfathomable, and frankly, ridiculous and awful that this is now become the leading cause of death for our children. We can do much more to change these kinds of things. You know, we urge the committee to have a favorable report of this.
Mr. Neistat,
bill.
please.
Thank you.
Neistat.
Excuse me?
2 minutes, go ahead.
Thanks. Hi, Delegate Clippinger, Chairman, members of the committee. Thank you for the opportunity to testify today on behalf of the Maryland Psychiatric Society in strong support of House Bill 934. I'm a psychiatrist. I specialize in suicide prevention, and I'm also the medical director of Hopkins' Center for Suicide Prevention. I've spent my whole career studying the role of firearms and suicide risk. What we know is that as firearm access has increased over the past several years, our suicide rate has climbed. There's actually been no increase in suicide attempts. The issue is that guns are available, so those attempts are much more likely deadly, so our suicide rate goes up. Firearms are uniquely lethal to suicide attempts. When a gun is used, there's little or no chance for a second chance. This makes firearm access one of the most significant and preventable risk factors for suicide. And yet many Marylanders remain unaware of life-saving interventions like secure firearm storage, temporary firearm transfer in times of crisis, and Maryland's Extreme Risk Protection Order, or ERPO. Research shows that ERPOs save lives, but they can only do so if people know they exist and understand how to use them. That's why HB 934 is so critical. Maryland has already taken an important step in establishing the Center for Firearm Violence Prevention and Intervention, but its work can only be effective if the public knows about it. Education is prevention. This bill ensures the center has the mandate and resources to develop and distribute educational materials so that individuals, families, healthcare providers, law enforcement officers have the information they need to take action before tragedy strikes. So by passing 934, Maryland will be taking an essential step towards reducing preventable gun deaths through evidence-based public education. I urge a favorable report on this bill. Thank you very much.
Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 934. We're going now, Delegate Addison, to House Bill 271. We'll hear from Delegate Addison, Afra Vance, Lisa May, and Nicholas Blendy. Delegate Addison is here. All right, Delegate Addison, please, for 3 minutes.
Okay. Good evening, Chair Clippinger, Madam Vice Chair Bartlett, and members of the Judiciary Committee. For the record, I'm Delegate Jackie T. Addison, here to introduce House Bill 271, Real Property Expedited Wrongful Detainer Proceedings, Property for Sale or Lease, something I call Swatter's Law. This bill seeks to amend existing real property laws to provide expedited legal proceedings and wrongful detainer actions, particularly when the property in question is advertised or listed for sale or lease by the complainant at the time of the complaint. House Bill 271 aims to address the challenges faced by property owners when unauthorized individuals occupy properties that are actively being marketed for sale or lease. The key provisions of the bill include expedited proceedings. The bill mandates that wrongful detainer actions receive expedited court proceedings if, at the time of the complaint, the property is advertised or listed for sale or leased by the complainant. This ensures a swift resolution to such disputes, minimizing financial and logistical burdens on property owners. 2, service of notice. It requires the notice of hearings or appeals in these expedited proceedings to be served in person. If personal service is not feasible, the notice must be posted on the property. Under Maryland current law, property owners facing wrongful detainer situations must file a complaint in the district court of the county where the property is located. The court then issues a summons to the defendant, and the process can be time-consuming, often leaving property owners in prolonged legal battles. For properties actively listed for sale or lease, such delays can have significant financial implications. Extended unauthorized occupancy can deter potential buyers or tenants, lead to property devaluation, and impose additional maintenance costs to the owner. I ask that you consider the case of Danielle Cruz, homeowner who in 2022 encountered a distressing situation after renovating her property with the intention to sell. Ms. Cruz discovered that unauthorized individuals had moved into her home without her consent. These occupants claimed to be victims themselves, further complicating the situation. The legal process to reclaim her property was prolonged, causing financial strain and emotional distress. House Bill 271 addresses a critical gap in our current legal framework by ensuring that property owners have access to expedited legal remedies when unauthorized individuals occupy properties intended for sale or lease. This bill balances the right of property owners with due process for occupants, ensuring fairness and efficiency in the legal system. I urge the committee to consider the positive impact this legislation will have on property owners across Maryland and to support the passage of House Bill 271. Thank you for your time. Go ahead.
Sure. Good afternoon, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, Nicholas Blendy, and I'm Assistant Sheriff and Attorney in-house for the Baltimore City Sheriff's Office, here in support of House Bill 271. You have our written testimony, so I won't go over that, and I'll just kind of outline our perspective since we are the people in Baltimore City who effect all warrants of restitutions, which are the eviction writs of the court. So there's 3 broad categories. There's failure to pay, there's tenant holding over, and there's wrongful detainer. Wrongful detainers are, of course, when someone has no claim of right to possess the interior of real property, no claim of right to a landlord-tenant relationship in writing or orally or in any sense. In effect, under certain fact patterns, they are also criminal actors committing what is effectively a burglary, I don't know what degree, probably 4th, of the interior of a house. There's also within this subcategory of squatters or people who have no legal right to be in there, what we've seen an uptick in Baltimore City, which is people either taking observation of lock boxes or properties listed for rent and cutting them off and moving into oftentimes staged properties that are listed for sale and making that their home for as long as they can ride it out. And there's even more perniciously a group of people who are preying upon people in need of housing and running a fraud scheme on them. And what I will say is that even and you're going to hear the opposition bring up some very credible and legitimate concerns that they have that I think we're actually way closer together than we are far apart. But even in the instance where somebody is the victim of a fraud, without a change in the law, we're still putting them out after the court process, right? You can be the victim of a fraud, but you don't have a right to possess, and that's what wrongful detainer does. It seems like my 2 minutes are nearly up, and I'll be happy to answer any questions, but I will say that the status quo is not particularly tenable. There is an uptick, and any actions would be welcome from our perspective. Thank you.
Thank you, Mr. Chair, members of the committee. Lisa May with Maryland Realtors here in support of the bill. We've appeared before you before. We've talked about squatting. We're not going to belabor that point, particularly at this late hour. But we are supporting any and all of the approaches to deal with the issue of squatting, including from Delegate Addison, from Delegate Conaway, and others that you have heard here in this committee, so long as they improve upon the current process, which is clearly failing homeowners. This bill would help in those instances of squatting, as the delegate described, when properties are listed for sale or for lease. And we thank her for putting these strict timelines in this bill that move this case through the entire legal process. And why that's important is I had a discussion with an attorney in a state that has expedited detainer, but not as specific as this. They were representing a property owner, trying to get the squatter evicted. They had the initial court hearing, and that squatter was very conveniently ill the day of that initial court hearing. They were granted a continuance and were able to squat in the property for another 4 to 5 weeks before it got back in front of a judge, and then they could continue along. And we think that is kind of re-victimizing a property owner that's had their property taken from them illegally. So as you work through this and the other proposals that you've had here in this committee, we want you to keep that in mind, really keep these property owners in mind, and thank you for your consideration on this issue.
Questions for the panel? Delegate Schmidt.
Thank you, Chair. Thank you, Delegate, for bringing the bill. I like the bill. And I'm sure you would figure that. Your panel had a couple things that I wanted to ask. Last year, Sheriff, do you go by Sheriff or Assistant Sheriff?
You can just call me Mr. Blendy, it's fine.
Sir
Titles are
Blendy,
weird.
all right. Sheriff Kogan had testified last year regarding a number of evictions that we had in Baltimore City. And I'm looking at your written testimony. Has that changed? Do we still have the same number of evictions?
It would depend on the category. There's a fluctuation. So do you want to know specifically about wrongful detainer, which is what this bill,
that would be great.
More broadly?
Yeah.
So wrongful detainer is about a little over, on average, 100 a month, and that is anecdotally an uptick. And that's a broad category. That's not entirely squatter situations. Sometimes there's fact patterns that are incorrect for wrongful detainer, which is why we agree what the opposition is going to bring up needs to be considered and thought of in a way to put proper protections. I think her bill goes a long way to doing that. But that's also like the category of somebody, the grandmother had the lease, and then she invited the grandson to move in, and then the grandmother died, and then the landlord showed up and was like, who are you? I don't have a lease with you. You don't have a sublease. So that's wrongful detainer. What I can say why we're particularly interested in wrongful detainer is for every 100, for example, failure to pay cases that get filed at the court, we only actually get around to evicting about 10 of those, because that's consistent with what we said last year, what the sheriff said, 10%. And of those 10, 8 when we show up to do the eviction are nobody's there, and then only 2 out of those 10 are there people on premises that we have to say, you have to leave the premises and vacate it. Either you're coming out with me, like either with my force or not, and typically we do a very good job of just talking people out of it. Wrongful detainer, for every 100 that get filed, about 40 of them actually end up with us having to effect the eviction, to serve the warrant. And it's almost reverse. Of those, about 8 are actually vacated at the time we serve the warrant, and 32 there's individuals on premises. So with that contact level, the more likely, you're not gonna have an incident if no one's there. The more likely you are to have an incident where force might need to be used is when somebody's obviously there, and these are tense situations. So to reduce that numerator in any way, or to accelerate the process so that the animus doesn't build in a way that protects both their rights and also the rights of property owners, I think that's why we're here in support of the bill. But I can say, if you're asking about, did the governor's bill lead to a reduction, as was the theory? I think initially it's probably too early to say, but yes, we have seen a reduction in filings across the board for those cases.
Gotcha.
That was your question.
I'm looking at the fiscal note here. I'm surprised that it doesn't state that we would have improved. speed, right? Should this bill pass, the speed is a little bit quicker, less resources are being utilized.
So
Would that help the department?
what I said for our response was that it would have no fiscal impact because we're going to serve this at some point. So whether it takes however many weeks, Ms. Lisa said that she had with her one example, or whether it happens in 5 days or 10 days or whatever the committee decides is appropriate for fundamentally fair due process for everybody involved, which is important to us, we're going to serve that that warrant rather. So whether it happens in 30 days or 60 days or 90 days, like that's what our field services division does, is they serve all the writs of the court and all the warrants. So it doesn't impact our budget. It probably has more meaningful impact on the property owners, the people seeking relief, but it doesn't have any impact on our operations.
Gotcha. Thank you. Thank you, Chair.
Thank you, Chair. Thank you, delegate and panel, for coming in to testify. What's the timeline for removal under this bill?
I think as drafted, it's what, 5 to 7 days? 7 days. Yeah. So, and I can say from our perspective, we have actually had dialogues with the district court about what appropriate amount of due process is, because we've actually, sometimes due to transmittal errors, things have come to us with, in Sheriff Cogan's opinion, inadequate time, and we have returned those to the district court. So we do think that some version of whether it's 5 days or 7 days, or if the committee believes that due process requires more or less, that is important to consider, and we would absolutely welcome whatever the committee believes, whatever the General Assembly believes meets that standard. We will adhere to it, and we think that those considerations are very important.
So you're saying you received your information from the district court? That's what you're saying?
Right. So how it works is
no. I'm just asking. Is that where you got the 5 or 7 days?
No, that's I think the text of your bill, right, Delegate? Yeah, I think it says within 5 to 7 days. I think is what the bill text says.
Okay. So thank you very much.
Seeing no further questions, we thank you very much. We'll go now to those people who are opposed. Elizabeth Ashford, Catherine Davis.
Good evening, Chair and members of the committee. My name is Catherine Davis. I'm the director of PBRC's Courtroom Advocacy Project. We represent low-income tenants in eviction-related litigation in Baltimore City and Baltimore County. We are for sure sympathetic to the issue that has brought this bill to the table, but we're requesting an unfavorable report because we're concerned about unintended consequences. The central issue in most of these cases is, in fact, whether it's true that the person doesn't have a right to be in the property. In our experience, they very often do. We already see the statute weaponized against tenants who have valid leases, and I would hate to see it amended in a way that prevents those tenants from finding counsel and mounting a valid defense. We recently represented Mr. Ragbuhar, who was current on his rent. When the landlord decided to sell the property, he filed a wrongful detainer against everyone living there. Because we were able to prove the existence of regular rent payments and a valid oral lease, he won his case. So he's currently, this was a very recent case, he's currently still there and looking for a place to live because he wants to move, but he avoided a quick and illegal eviction that would have resulted in him living in his car. If the timeline is shortened, many people like him will not have a chance to arrange to come to court. They won't find counsel, they won't prepare their defense, and they'll result in illegal evictions for Maryland's most vulnerable families and individuals. So before we move forward this legislation that runs the risk of perpetrating illegal evictions, either on those who are themselves victims of fraud or those who are actually rightful tenants, we need data. So we need to know the true scale of the problem. We need to know, what is the actual frequency of these actions in Maryland, and not just the wrongful detainer actions that you were just discussing, but how many of those involve tenants who are actually rightful tenants. And how many are actually victims of fraud themselves and innocent victims. The Judiciary could probably provide that data, and also how long it actually takes for the process to move through the courts. But without this data and protections for clients like ours, we are requesting an unfavorable report. Thank you.
Chair, members of the committee, Albert Turner, the Public Justice Center, sitting in for Elizabeth Ashford, who could not be present. If I may just acknowledge our thanks to Delegate Addison, on allowing us to have these conversations with her. We've been having conversations with her about this situation for time, and she's given her ear to us. So we appreciate her for that. We are unfavorable for the same reasons that we've been unfavorable for all these other bills, is that we do not believe that this bill is narrowly tailored to address the situation that it is looking to solve. One of the reasons being is that for the purposes of the constitutional due process is that meaningful notice and a hearing is required. 5 days is not a meaningful amount of time for the notice to be sent, to be posted, for the person to adequately mount a defense if there is a defense, and to be able to defend themselves. The bill as constructed only requires a posting of notice of the trial. It does not require mailing of that, which means that for the purposes of someone who might be out of town, might not be able to look at that notice within that time, that very, very short time frame, they would not be able to mount a proper defense, which we believe is a violation of the Constitution, constitutional due process. I'll also note in our own written testimony, there's also a Attorney General's testimony acknowledging the same, that for this bill, as constructed, it does have very serious constitutional due process questions. I'd like to also note in regards to, as well as PBRC, we also have clients where in many cases the landlord has bought a property and has taken on tenants, and thinking that these tenants are not his own, he files wrongful detainer, which is incorrect. And because of that, he tries to get the eviction. And for those reasons, we ask for an unfavorable report.
Questions? Seeing none, thank you both very much. That concludes the testimony on House Bill 271. Going to House Bill 180 now. Delegate Addison. Apparently Delegate Young standing in for Delegate Addison, which is not something we usually do. Stephanie Mavronis, please.
Thank you for the pinch hit today, Mr. Chair. Mr. Chair, members of the committee, Delegate Young, pinch hitting for Delegate Addison on House Bill 180, the Gun Violence Victim Relocation Program. You all have heard this bill before, so we won't be before you long. Last year, you heard about, or previously, when you last heard about this bill, you heard about the tragedy of the Dawson family. Today, I want to tell you about a success. We're going to call the young man Romeo. That is not his name, but that's what we're going to call him. When we were sworn in on the first day of this term, at about 11:30, I received a text message from the Baltimore Police Department that Romeo had been shot down the hill. I'm going to leave it at that for those who know what down the hill is. He was shot by somebody in the neighborhood that he knew, who he had seen, et cetera, et cetera. As a consequence of that, I worked with Monzi, and I called Mr. Mark Mason right here to help me find a location for him to move. Obviously, one of the biggest challenges that we had was resources. Now, over time, we were able to find a location for him. I was sitting right there, Delegate Sample, who's talking to him and texting with him over and over and over again about this person and trying to get him out of that neighborhood. And he has moved out that neighborhood. And he moved out the city, and now he goes to church. He's doing well, he's healthy, and we're glad that we were able to get him out of that situation, get him resources, and now he's moving in a more successful manner. When we think about the group violence reduction strategy in Maryland, in Baltimore, we know that it's been successful. This year, it's reduced crime or homicides of 30%. And that's on top of the over 20% from last year, on top of the over 20% from the year before. We've been working really hard in Baltimore to make sure that we deal with folks on a case-by-case basis. Group violence reduction requires that we address people's needs as they need them. But the problem, as you well know, is often making sure that we have the resources to do that. So that's what this bill asks for. It asks for us to appropriate money to make sure that we can move folk so that way they can get out of the situations that they're in and into a better situation. And when we do that, we build public safety. I call on this committee because you have a role to play in building public safety in Maryland. We can export the success that we've had in Baltimore throughout the state of Maryland. And that's why I asked for a favorable report. Thank you.
Thank you. Good evening, honorable members of the committee. I'm Stephanie Mavronis, Director of the Mayor's Office of Neighborhood Safety and Engagement in Baltimore. As the leader of the city government agency responsible for violence prevention and intervention efforts, I cannot overstate the importance of comprehensive services that support victims of crime, surviving families, and next of kin. Timely, efficient relocation of those at the highest risk of gun violence has direct implications for safety. It prevents retaliation. It prevents further victimization. And efficient victim services, as we see every day in our office, not only for direct victims, but also to their family members, as well as intended targets under threat of violence, has the added benefit of facilitating cooperation with law enforcement without fear of retaliation. When people know they're safe, they're more willing to participate with our institutions. They're more willing to submit their testimony and be a part of that process. Since late 2023, Monty's Victim Services Lane, led by Chief Mark Mason, who's here as well today, has supported more than 50 households with relocation support, including helping cover security deposits and up to several months of rent. We work very closely with the victim services units at the Baltimore Police Department and State's Attorney's Office to try and do this work in the most effective way possible without a dedicated, streamlined source of funding. For example, our victim services team relocated a gunshot victim who was shot just feet from his home in a robbery attempt. He knew who shot him, but was afraid to share that information while still residing at that home, and feeling that talking to law enforcement in that moment before reaching a safe place to stay would put him and his family in imminent danger. That's just one of the stories and one of the cases that we support. We're committed to doing everything we can to support victims across Baltimore. We sincerely thank Delegate Addison for sponsoring this legislation and urge the committee to consider the way that effective victim services funding plays a direct role in helping us promote and continue public safety gains. Thank you very much.
Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 180. Going to House Bill 403 and Delegate Pippy. Did I miss somebody online? Okay, I'm sorry, I have to roll it back. Oh, no, she's not. She was scratched. No, she said she wasn't. Pippy, yeah, Delegate Pippy, 403. There's one person in opposition, Jonathan Green. Okay, Delegate Pippy for 3 minutes.
All right, thank you, Mr. Chair, Vice Chair, honorable committee members. Happy to be back in the Judiciary Committee. Delegate Pippy for the record in support of House Bill 403. So this is what this bill does. It just says for certain individuals that have committed certain crimes, violent offenses, that also happen to be here without documentation, that they would otherwise basically participate with the Department of Homeland Security. We've heard a lot of these bills related to illegal immigration and undocumented. This bill is a criminal bill. It deals with only individuals that happen to be here without documentation that have committed a very, very serious offense. And what the bill does is just says that they have to cooperate with the Department of Homeland Security. And the reason we're bringing the bill is that we've had certain jurisdictions throughout the state that have, for some reason, just refused to cooperate. And I think, we all have a responsibility of public safety. It's a tricky situation when you have an individual that, in addition to committing a violent offense in our state, but also has documentation issues. I think at that point it's appropriate to work with the federal government as they are in charge of immigration in this country. That's the way the Constitution is set up, that the federal government is in charge of immigration, and we want to make sure that we're doing our part to cooperate and make Maryland a safer place to live. So with that, happy to answer any questions. I'm not going to go into all the details of all the different crimes that have been committed throughout the state by individuals that are kind of in this predicament, and some that have made national news. I'll spare you that. But I think I just want you to narrow the thought process that this only deals with individuals that have committed very serious offenses, and we need to deal with that situation appropriately. Thank you, Mr. Chairman.
Questions? Delegate Conaway?
Thank you, Chair. Thank you, Delegate, for coming in. And if they don't cooperate, what happens?
Well, look, if this committee passes the bill, it would be a requirement to cooperate. So I'd have to see what the penalties of that would be, but I think more importantly, it's basically setting the tone.
No, I was just asking for the penalty. Thank you very
Sure,
much. I
don't have it.
irritate
Yep,
the chairman. Thank you very much.
Thank you. Yep.
Okay. Any other questions? Delegate Tomlinson.
It's hard to follow that. Thank you, Mr. Chair. I know you're not, it's gonna be hard to believe this, but the Public Defender's Office, they are in opposition to this. They posed the question, who determines whether a person is an undocumented immigrant? I feel like this is probably defined somewhere.
Yeah, I will tell you, I enjoyed reading their letter of opposition because they had an issue with the fact that I called these individuals undocumented individuals versus the feds, they use the word illegal alien. So I just want to point out that the public defenders had an issue with me using undocumented versus illegal alien. So I'm happy, if the committee wants to amend the bill to say illegal alien to help the public defenders, we certainly can do that.
Thank you.
Seeing no further questions, we thank you very much.
Thank you.
We're going to go now to, in opposition, Jonathan Green. Jonathan Green, please, for 2 minutes. Jonathan Green.
Yes.
Going once. All right, good. For 2 minutes, please.
Thank you, Chairman Clippinger and members of the Judiciary Committee. My name is Jonathan Green. I'm sorry. May I proceed? Thank you. I'm an attorney practicing in the Maryland Bar for more than 25 years, and I'm here on behalf of the Maryland State Bar Association's Immigration Law Section. We oppose the bill and ask for an unfavorable recommendation for several reasons. First of all, the bill as created does not work with current immigration law, federal law, and it may create an unintended violation of both state law and the Constitution. It's not enforceable because, again, it uses the term undocumented immigrants that is not defined in federal law. So the term illegal aliens is also not a term that is defined in the Immigration and Nationality Act, neither in regulation nor statute. It also creates, it impermissibly broadens who can request transfer of persons to the custody of the Department of Homeland Security. Only specific federal immigration officers authorized by the federal regulations at 8 CFR 287.7b can make the request to impose a detainer. And this bill creates an incredibly broad category of people that's not in compliance with federal law. This bill also turns the voluntary nature of the request under federal law into a mandatory obligation, again, that violates federal law. Federal detainer regulations only refer to a request to obtain custody of a person. No mandatory obligation under federal statute or regulation, and our Attorney General in the state of Maryland has raised questions about whether doing so violates other laws, constitutional provisions, or the Maryland Declaration of Rights. State and local employees should not agree to the detainer requests if they violate such laws and provisions, and this bill unnecessarily places state and local agencies at risk. Finally, this also requires transfer of custody to the Department of Homeland Security while a sentence is being served, which is something that's not permitted by Maryland law. So please, for these reasons, we recommend unfavorable report. Thank you.
Seeing none, thank you very much. That concludes testimony for House Bill 403. Delegate Szeliga. Don't see Delegate Szeliga. Delegate Chi. Delegate Chi and House Bill 1445. I'm going to go with her bill. It is only her. There is one person in opposition, Mr. Malloy. Okay. He doesn't appear to be in the room right now. Well, we'll find out. Go ahead. Delegate Chi for 3 minutes.
All right. Thank you, Mr. Chair. Good evening, everyone. It's late. I'll make it quick. Delegate Chi here presenting HB 1445, licensed funeral establishment, provision of fact sheet on real property ownership. As we know, communities across the state have been struggling with vacant and unmaintained homes for decades. Often it is due to something called tangled titles, when there's confusion or no clear home ownership because the homeowner passed away without transferring the deed or leaving a will. When there's a tangled title, the current occupant of the house or the person who believes to be the rightful heir of the property has to spend thousands of dollars in legal fees on navigating probate court and dealing with the register of wills to clear a deed transfer. It is a stressful and a costly process. Often people just give up and leave the property vacant and unmaintained because without the proper title, it is difficult to take out a home equity loan, obtain homeowner's insurance, or qualify for home repair programs. Tangled titles contribute to community blight, hurts generational wealth building, and reduces local counties and municipalities' property tax revenues. So HB 1445 offers some relief to families of the deceased by requiring the DHCD, the Department of Housing and Community Development, to develop and post on its website a fact sheet about tangled titles. The fact sheet will simply include basic information on the steps necessary to remedy a tangled title, the probate process, and how to obtain free or low-cost legal services for low-income residents. The fact sheet will be shared with families by licensed funeral establishments, including crematories, during the course of their service to the immediate family members, as required by this bill. The HCD has confirmed that they're willing and capable of developing the fact sheet with existing resources, and we believe this is a small ask of the funeral homes and the crematories as a form of public service, because most of the times people just don't know there are such processes and services in place. We believe this is a good first step to lessen the stress of the grieving Marylanders who have just lost their loved ones and to reduce the vacant housing stock across the state. So with that, thank you very much.
Questions? Delegate Sample Hughes.
Chair, it'll be brief. Thank you, Delegate, for the bill. I just want to ask you just two things. At what point in the process would you expect the funeral director or funeral establishment to provide such report to the family and expect it in return?
We don't stipulate that in the bill. I think this is up to the discretion of the funeral homes because it could be more than one encounter with the family members in the process of the services. And, you know, we simply ask that they provide that information. They don't have to develop that information. And we require the HCD to not only develop the information, but post it on their website in a printable format. So all the funeral home needs to do is to download it and give it to the family members in case it's useful to them. It costs them nothing,
so if they don't
basically.
complete it, there's no penalty to myself as a funeral director?
Well, I believe in the bill, we say that they need to meet that requirement, but I don't believe there is any immediate penalty for that.
Okay.
Yeah.
Okay, thank you so much.
Yes, very briefly, Mr. Chair. I wanted to give you an opportunity to respond to the Funeral Directors Association's assertion that that it's inappropriate for the funeral director to be giving them this information. And what is your response?
Yes, I read the testimony, and I appreciate that perspective. I agree it's an emotionally difficult time, but this is a form of public service. This is not like a funeral service also selling them something, you know what I mean? And also if you think about the whole process, even acquiring a death certificate is optional, right? So it's not something that happens right away, like a funeral home encounter for some families, okay? So the funeral home or a crematory is probably the most reliable point of contact, other than maybe a government entity at some point where that place would issue a death certificate. So we think that's the best place for people to be informed, unless you can find a better place to make sure people are informed. And we believe, you know, without asking them to even distribute that. We just, to develop that information, all we ask is they give them a copy of that.
Seems simple to me. Thank you, Mr. Chair.
Thank you, Mr. Chair, and thank you, Delegate. This is one of those challenges that we're facing with tangled titles, with passing property from one generation to the next, and it's particularly a challenge in the African-American community. So I appreciate this bill. But you mentioned something, and I'm trying to think through. Is there anything else we require the funeral directors to share? So is there anything else so that this would not be the only thing?
That's a great
Are you
question.
aware?
I actually don't know if the government requires funeral homes to provide anything other than what they usually provide to families for what they need to know about the burial process or something, right? I actually don't know if the government asks them to do anything at all.
I'm just trying to think if there is, then this argument is probably not as significant, but.
Yeah, well, and also their letter mentioned that they may inadvertently invite questions that they cannot answer. I don't believe that is a matter of serious concern. You know, they can say, this is where you need to go to seek that information.
I would think that the fact sheet would tell them where they might
Right,
need.
exactly. That's the whole point.
All right.
Right.
Thank you.
Seeing none, thank you very much, Delegate.
Thank you.
William Nathan Malloy. In opposition, he's going to get 2 minutes to speak. Speak, please, into one of the microphones there. Mr. Malloy.
Thank you, Mr. Chair, Madam Vice Chair, esteemed members of the committee. My name is Walter Nathan Malloy Jr. I am a licensed funeral director, been a funeral director for 16 years. I'm an attorney and the lobbyist for the Maryland State Funeral Directors Association. Upon reading the bill and discussing it with the members of the Maryland State Funeral Directors Association, we find it inappropriate for the funeral director to present such information to a family. Having participated in many funeral arrangement conferences, it's often a stressful and difficult time for the family. Often there are issues among the family just even trying to decide when to have the funeral, when to bury mom or dad, whether to cremate or bury or not. And those situations and discussions can become even more tense. Trying to introduce a document about heir property where there may be competing claims and beliefs about who was and who is entitled to the property would often cause the situation to spiral out of control. And in fact, it's not the interest or the position for the funeral director to even be involved in that discussion. This is a responsibility for the Register of Wills or the Housing Department to give legal advice, not the funeral home. And the reliance on that advice, if something is stated incorrectly, could pose a liability to the funeral establishment and the funeral home. Not to mention, in the Morticians Act, Title VII, there is a statement in Section 7508 that says if you fail to abide by this act, which is going to place the requirement in the act, you are subject to, we were guilty of a misdemeanor, you could be imprisoned or fined. Not handing out this sheet would expose funeral directors and funeral establishments unnecessarily and unfairly. For these reasons, we ask that the committee issue an unfavorable report on this bill. I'll take any questions if there are.
Any Delegate Phillips?
So, and I understand, we're not trying to criminalize, I don't think there was any intent to criminalize funeral directors in this particular mindset. I think you heard that the maker of the bill wants to educate. And I'm not sure that there is another place where families come together where the state might have an interest outside of the funeral home. Are there any other things that you generally share? And most of the time there's a pamphlet, right? I mean, I've buried both of my parents with Vaughn Green, and they always provide a pamphlet of information, some of which they go over, some of it they don't go over at all, but there's just basic information about the funeral preparation. Is that generally the case with most funeral directors?
Funeral directors are required to have a contract under the law. They're required to share the general price list under the FTC requirements. These are things that we are required to do throughout the funeral process. Some funeral homes issue marketing materials, some do not. With regards to a point more appropriate, please note that every funeral, every deceased individual must have a death certificate filed with the state. As such, on that death certificate, there's a section that says informant, meaning that's the individual who provided the information on the deceased, and their address. The state can access that information and send out as many pamphlets as the state wishes. But I don't think it's fair to the funeral directors that are trying to navigate this touchy subject with the families regarding the death to put them in a position and require them to send something that if they were to forget to send it, they're now subject to sanction. It's not, in my opinion, the funeral director's position to or obligation to educate the family on housing law. It's their obligation to educate them on funeral law. There's also multiple forms of disposition, one of which is a burial, another is a cremation. The families have to negotiate often with the cemeteries to provide that information. Now, I'm not advocating that you put the onus of the burden on the cemeteries, but again, there are other touch points that is really not appropriate for funeral directors to be involved in educating individuals regarding housing and real estate law.
So what if we took it beyond housing and there's the touch point, which is the death certificate, and we asked Vital Records to also include information about probate, housing, and that would go with the death certificate. You would be then still obligated to provide it because you're providing the death certificate.
Only if they purchase the death certificate from us. They can get their death certificate directly from Vital Statistics, and they do not have to purchase it from us.
And if you're handling the funeral, how often do families get their own, and how often do you do it for them? What's the percentage?
That's a tough call. I'll say most, 80, 90% will get one or two, but then they'll eventually order more when they find out they need one for MVA, or they need one for another insurance policy, or they need one for another issue. So,
but if you were to get it and that was a requirement, you'd have to do that, right?
I'd have to do what?
You'd have to provide that additional information.
If it was a requirement that I provided?
If it was a requirement that came with the death certificate.
I presume.
Okay, thank you.
Seeing no further questions from the panel, thank you very much.
Thank you, sir.
And that concludes the testimony on House Bill 1445. Now, Delegate Schlager, House Bill 653, which appears to be the same as Delegate Pippy's bill, except you also exclude people from the sex offender registry.
Yes, I haven't read his bill.
Okay, go ahead. 653.
Thank you so much. If it makes you feel any better, we still have two bills in HGO. For the record, my name is Delegate Kathy Shalega. I'm here today on House Bill 653. And this just holds up the basic principles of law and order and public safety. As you know, in Judiciary, we are a nation built on the rule of law. And when we fail to uphold that law, we fail the very people we've sworn to protect. This is about ensuring that those who have broken our laws in the most violent and egregious ways are not given another opportunity to harm innocent Americans. This bill is very simple and straightforward. When an undocumented immigrant, which by the way, I read the opposition testimony, if that word is not correctly noted, it can easily be amended, is convicted of a violent crime, terrorism, sex crimes, pedophilia, or gang activity, our state and local jails will work with federal authorities to ensure that they are transferred to ICE custody. We're not talking about ordinary immigrants seeking a better way of life. We're talking about criminals who've already victimized members of our communities, criminals who should no longer be allowed to walk free in our country. History has a way of reminding us why strong leadership is necessary. If we look at the tragic cases of Rachel Morin and Kayla Hamilton, we see the consequences of inaction. These young women lost their lives to criminals who should never have been here in the first place. Kayla Hamilton's killer was an MS-13 gang member who had already committed murder and sexual assault, and yet he was allowed to remain in our country only to take the life of another innocent young woman. Public safety is not a partisan issue. This is a fundamental responsibility of government. Local and state law enforcement must cooperate with ICE to remove violent criminals. What you may or may not know is that, I think this is the 5th year I've had this bill, judges sometimes shorten the sentences of illegal immigrants, assuming that they will be deported to save taxpayer dollars for incarceration. But when state and local governments refuse to cooperate with ICE, these criminals are released instead of given over to ICE. There is polling issue on this issue. It's in the testimony. This is an 80-20 issue. This is not a partisan issue. In September, I polled this exact question of this bill. 84% agreed, 81% of Democrats, 95% of Republicans, you won't be surprised about that, but 90.3% of African Americans agreed with this actual bill, and you can find that in the testimony.
Delegate Erican.
Thank you, Mr. Chair. Thanks for being here. There's been some cases in Prince George's and Howard County, I thought. Oh, I'm so sorry. There's been some cases in Prince George's and Howard County. I thought you might want to touch on what's been happening in those areas.
Thank you, Delegate Erican. And these are the counties that are not cooperating with ICE now. So I've spoken to Matt Elliston, and he was going to be here tonight or today he was hoping, to testify in favor of this bill, but he is out of town. He's in complete support of this bill. Since Howard County and Prince George's counties have become sanctuary counties, Howard County they've had 120 detainers in Howard and 649 in Prince George's County. And people with previous convictions for murder, 6, carjacking, rape, guns, weapons, domestic violence, cocaine, selling and possession, drug trafficking, sex offense against children, concealed weapons, DUIs, sexual exploitation of minors, racketeering. There are actually 4 particularly egregious criminal illegal immigrants being held in Howard County right now, and they will not cooperate with ICE. One of them is convicted of raping a child, a 12-year-old, in front of a 3-year-old. So, you know, these are not people that should be let out, but ICE wants this person, they're to obviously deport them. So when their sentence is completed, this makes sense. They should be turned over to ICE and not put back in the community.
Seems very reasonable. Thank you.
All right, that's the questions for this panel. Thank you very much, Delegate. We'll go to Jonathan Green.
Thank you, committee.
Jonathan Green. Mr. Green, as I mentioned ago, it's basically the same bill as Delegate Pippi's, except it adds people who are on the sex offender registry. So please begin for 2 minutes. Unless you can't hear.
I can hear. Thank you very much, Chairman. I appreciate this. I'm not going to repeat the testimony that I gave earlier on Bill 403 because that's a similar bill. But I do want to point out that the State Bar Association of Maryland's immigration law section, we support good laws that work for the state of Maryland and for the federal government. But we understand that the immigration enforcement is the responsibility of the federal government. The bill as drafted starts to create immigration enforcement responsibilities for the state of Maryland, which don't match with federal law. So we think that the federal government should carry out its immigration functions, and the state of Maryland should carry out its criminal law enforcement functions and the proper functions regarding custody of people who are in our local correctional facilities. This bill, again, does not use terminology which would work with the Immigration and Nationality Act or with federal regulations. So it's not simply a matter of we can simply change a word. It's the complete terminology of the bill. Just as drafted, it cannot work. It doesn't function properly. And it seeks to change the entire system of how detainers work. The federal government created its regulations, and it wants the communities to work with the regulations. This bill changes how our state would work with federal regulations. And it doesn't work with what the government wants, the federal government wants. So for those reasons, we don't think that this is a good bill, and we recommend that it not be approved. Thank you.
Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 653. We go now to Delegate Schmidt and House Bill 982. John Jocelyn, Carla Mooney, Mark Pemak, and Mr. Lay, by any chance? No? Delegate Schmidt, if you'd like to begin, as he...
Thank you, Chair. I think a good amount of the witnesses had left already. Thank you, Chair. Thank you, Vice Chair. Thank you, Committee. We've heard this bill a number of years. I'm carrying this bill on behalf of some of our former delegates that I proudly represent. So for the record, Stuart Schmidt, I come before you today to humbly present House Bill 982, theft of a handgun, Gun Theft Felony Act of 2025. I'm here to emphasize the critical importance of differentiating theft of handguns as felony offenses rather than just a misdemeanor. This distinction is paramount in addressing the severity and societal impact. I wish that Delegate Lopez's panel was still here. They shared some amazing statistics regarding homicides. But one thing I want to highlight is the suicides. That's really where a lot of these stolen guns end up. According to recent statistics, Maryland State Police, handguns are the most commonly used firearms in violent crimes across our state. In fact, I just looked this up, 60% of all firearm-related homicides in Maryland involve handguns. We had a chance to get a briefing from the MSP Gun Center earlier this year. I'm not going to belabor you with numbers. You know that's my forte. Marylanders polled, 89% want this as a felony. Many people ask me what is one thing that I'm working on this session, and I talk about gun theft felony. They are floored that it's not already in law. You've heard Delegate Moon's bill, House Bill 413. You can reference some lines there that talk about making gun theft a felony. This is the year I believe that we can do this. I really do. And I think it starts with the committee. There's some amendments that were proposed as far as narrowing the scope of what a firearm is. I support those amendments. And I stand here in support of House Bill 982. Thank you.
Hi, my name is Carla Mooney from District 29C. I represent Women for Gun Rights. I came in for this bill on the Senate side as well. I absolutely support making it a felony when someone has stolen a firearm. It's not a tool that's worth $500 that should be a slap on the wrist. That person can take that tool and now become a criminal by holding someone up with it, by shooting somebody with it. This is not the same as something with the value of a misdemeanor theft. I really, really believe that our communities would be safer if there was a consequence to stealing a firearm. Someone who has stolen a firearm slapped on the wrist, if they decide in a year that they want to follow the actual regulations to buy a gun, they still can. And I find that frightening. Let's make criminals responsible for their crimes. Please make this bill pass through this session.
Questions? Delegate Tomlinson.
Thank you, Mr. Chair. We've got a couple different gun-related bills here today, and different groups have come in support of the others, and I don't see them. Obviously, they're not here. There's nobody here. But I don't.
I'm a little surprised, Delegate. I'm a little surprised they're not standing behind me. I was expecting them to be here. Yep.
But even the testimony There, a lot of these same organizations, I don't see them listed as favorable. And my question is, have you had any conversations with them? Because I know, for, the Moms Demand Action, when they come and work the halls, I always meet with them and I hear the bills they're concerned about, and I always bring up several bills that I ask them, or I suggest to them that this should be something they should be getting behind and supporting as well. And this bill is a bill I think I've brought up all 3 years now. Have you had any conversations with an organization such as them or any of these other groups and asked why, why are their names not on here as favorable?
Yeah, great question, Delegate. Thank you. And I did bring that up to them in my private meeting with them as well. I also reached out to their lobbyist asking for some support amongst many of the other organizations as well. I will tell you, if you look at some of the statistics on larceny in the state of Maryland, 52% is more white Marylanders steal more often than others. So I'm not sure if there's some reasons why they just didn't support that bill totally. But I asked specifically why they didn't support this bill. And I did also reach out to multiple caucuses throughout the House for support. I will tell you there is bipartisan support. 46 people signed on to this bill, 46 delegates, and there was also 15 senators that signed on, both with bipartisan support, and a number of the members of this committee had signed on as well.
Cool. Thank you.
Seeing none, thank you very much. That concludes the testimony on House Bill 982. Now House Bill 1197, being presented, I believe, by Delegate Valentine on behalf of the Frederick County delegation. He's the only one testifying, I think. I don't know. There's nobody else out there.
I have a panel of one.
All right.
I'm the only one between us and a voting list.
Okay. Everybody get that last part? Delegate Valentine for 3 minutes.
Good evening, Chair Clippinger, Vice Chair Bartlett, and members of the House Judiciary Committee. For the record, Delegate William Valentine, representing District 2A, Washington and Frederick counties. I'm before the committee today to present House Bill 1197, Frederick County Sheriff's Salary, on behalf of the Frederick County delegation, of which I am a member. This legislation, in one form or another, has been brought forward by the delegation during each of the 3 years I've been in the General Assembly, and before that time. It's not an easy piece of legislation, and I'm aware and respect my colleagues' concerns and reservations about this legislation. You may ask, why bring this legislation again this year? The current salary for an elected position of sheriff in Frederick County has fallen so far behind that I believe, and some of my colleagues believe, it has impacted the decision-making process of individuals when deciding whether or not he or she should be interested in running for elected office within our county. I believe everyone in this committee can agree we all want the most qualified individuals running for an elected office such as this, and one that is as critical for public safety in all of our respective counties. I ask each member to think about his or her delegation and the disagreements and debate that often occurs within these delegations. Frederick County's delegation is no different. Our delegation has disagreed over this legislation repeatedly over the last 3 or 4 years. But this year, several members of our delegation on both sides of the aisle and in both chambers sat down and debated all of the available options. What was the result of this? I believe both sides walked away both satisfied and dissatisfied. Both compromised. This amended piece of legislation is a result of that compromise. It reminded me of last year's floor debate regarding a local courtesy vote, in which we can all remember was said, we don't always agree in delegations, but when the vote is taken and the bill is sent to a committee, it's done. The decision has been made and local courtesy goes forward, especially in those cases when it is something that specifically deals with the county that cast the vote. I've tried to uphold this standard throughout my time within the General Assembly, and I believe my voting record reflects that as well. The bill as amended would alter the Frederick County Sheriff's position salary to be set at 82.5% of our elected Frederick County State's Attorney salary, or the equivalent of $187,000 and $187,313, which would include increments and salary adjustments authorized from the calendar year and subsequent years moving forward upon time of a new sheriff's election. This legislation was supported by the Frederick County delegation with a favorable vote with 12 in the affirmative, 2 opposed, and 1 absent. This bill is also cross-filed, and I respectfully request a favorable report and am available for questions.
Delegate Tomlinson?
I saved all my questions to the end. I didn't get any texts. As a fellow Frederick County delegation member, and you know how much I look forward to those very large and sometimes contentious meetings. Versus our little baby Carol delegation meetings. Can you just do 2 things? Can you explain the duties, and I explained this last year with Carol's situation. Mm-hmm. Every sheriff's a little bit different in each county. Explain some of the responsibilities the Frederick County Sheriff has and why you decided to, I know you mentioned the 82%.
Okay, I can explain both. First, in Frederick County, the Sheriff's Office, and like many counties, is a full-service sheriff's agency, which means 3 things. They're the primary law enforcement in the county. The agency is also the operator and custodian of inmates at the county detention center, as well as their judicial responsibilities. The second part of that, and what I researched because I was really curious about, was in the last year I could find data. The Sheriff's Office employs and is under the direction of the sheriff over 400 full-time equivalent employees and maintains a budget of almost $70 million. With respect to, and I'm certain I'm not discounting our local elected state's attorney, whom I worked for at one point and have the utmost respect for their office, that comprises 87 full-time employees with a budget of a little over $11 million, both substantially less. And we are still, and both have separate responsibilities, I understand that, but it just puts in perspective the amount of responsibilities that an elective sheriff has in Frederick County. Secondly, to your point of the 82.5%, which I thought might be a question, was why we came on 82.5%. 12 jurisdictions in this state link their sheriff salary to something, whether it's a state's attorney, someone on the state police pay scale, different county police department commanders. One county links it to a judge. In our negotiations, one side of the aisle, we came in one side, the other side, and we met in the middle, okay? So in those deliberations, which were very forthright, they were very intense, one side wanted to be at 80%, the other side wanted 85%, so we met in the middle at 82.5. Everything was negotiated, everything was on the table. This was the best available bill we thought that we could come to. So with that, I'll answer any other question. And the only other part I will add to that is, not only has this not been raised since 2014, I did additional research. I went back to 2005. So this salary of this position has been raised 1 time since 2005, or the equivalent of 21 years. So we just would like to get this, by attaching it to another position, we will not have to revisit this, and that is our goal.
I heard what you said about local courtesy, and that's correct, but I sometimes wonder with these with these salary bills, whether all of us wouldn't be better off making sure that they actually take effect at the beginning of the next term on January 1st of 2027. What do you think about that?
That's when this would take effect.
Are you sure? Because the effective date, it looks a little different.
I actually asked the delegation chair's staff about how it is written in the bill. And what I was told, I did this earlier today because I caught that exactly on the amendment. And on that amendment, the way he told me was that it was drafted that way because the intent is to tie to what the state's attorney's office salary is today or this year. It will not take effect until after the next term. And that was the terminology, was based on the salary today in 2025.
Okay. Delegate Moon.
Sorry, I just, thank you, Mr. Chair, just a basic question. Who pays the salary?
Frederick County government.
Okay, and then I guess the basic follow-up there is, has the county government weighed in on the request?
Officially, no. I will say I have correspondence here. I do not want to misquote. While supportive of increasing the sheriff's salary, we are not formally supporting or opposing the bill at this time.
Okay, thank you.
Is it informational testimony? It seems sort of passive. All right.
They are electing, from what I was told by my delegation chair staff, they are not putting an official position in writing.
All right.
Either way.
We've had enough fun. That concludes the test. I'm sorry, Delegate Boucher with the very last question on this bill.
Thank you. Very quickly. Thank you, Chairman. Thank you, colleague, for bringing the bill forward. In light of the fact that the salary would not go into effect until the beginning of the next term, inflation is in place, and budgets are tight, would it not be prudent to wait until next session to address this salary bill?
Well, to go back to the beginning of my testimony and what some of the reasoning behind doing it this year was so that it could be in place for the next elections, for the election cycle we are about to begin with. If that makes sense. So the salary's in place. You know what the salary is for the next pending election.
Well, wouldn't it be in place after the next session? Because the elections are after the next session. So wouldn't it mute that argument?
The filing deadline, as the chair just stated, is before the next session would be
Yeah, but the
over.
election's after.
The election is after, yes. But the filing deadline would be.
So you think that the salary should determine or weigh in whether someone runs or not?
I believe that has been relayed to me by individuals. That has always been a situation where individuals are concerned about that, yes.
All right. Well, thanks for your honesty.
I commend the delegate to the legislative history of the salary of the Baltimore City State's Attorney. All right, any further questions? Since no one's getting that joke, I feel we're pretty old right now. No, Delegate Embry does, but you should take a look at that. You have to go back to the O'Malley administration. That concludes the testimony on House Bill 1197. That concludes the bill hearings for today. Committee. Kara is not a miracle worker. She needs until 8 p.m. exactly, 6 minutes, in order to get this done and get us ready for a voting session. We will be back in 6 minutes. Thank you very much.